Lord, with your lordship, kind leave, my lord. For such mentioning, my lord, I may be excused for such mentioning. I am tendering my unconditional apology for the first. My lord, the court number 5. My lord, this is a heavy matter. And since before vacation, we listed motion. We are not been able to, my lord, to take up the court is not able to take up the matter. 7 times I have mentioned. And this matter is heavy matter. Today says that no mentioning from the monthly list. Well, we are abusing from our clients. It says they are putting question of integrity of an advocate. Well, while you also kindly intervene in this matter, otherwise the bar is suffering and suffer immense.
Did it show the list? It's running in the list today.
Yes, 1591 in the monthly list. We mentioned before vacation, and the court is, the Honorable Judge is saying that, I am not saying, my lordship, my lord, make another bench for the motions. Otherwise, the motion will not be ended. New motion is not, this is a new motion, my lord. 1591. This is, my lord, I am representing the Medical College Hospital, my lord. He is suffering a threat of contempt, my lord, from the Consumer Forum orders, my lord. This matter went to the Honorable Delhi High Court. Delhi High Court says that the Judicial High Court you file. Then file the Judicial High Court. We are mentioning the matter. Another bench might be constituted, my lord.
I'll do something today.
Yes, my lord. Deeply obliged, Your Worship, my lord. For such disturbing in the morning, my lord,
No.
Again, my lord, tendering my unconditional.
No.
My lord, may I be permitted to mention an application for inclusion in the list?
Yes, sir.
Permitted to mention a matter of urgent listing tomorrow morning for public interest litigation. On the 22nd of March 2024, the government of Karnataka had red flagged a particular company for giving contaminated saline. They had been banned for 3 years. It was intimated to the government of West Bengal also. In spite of the order passed by the government of Karnataka, the saline was continuously being used. And this would have never come to the light until one lady who went to deliver a child.
We read in the newspaper.
Give it at
But yesterday, some action has been taken by the state government.
The state government brought 3 of those persons who were critically ill to Calcutta.
No, against these companies or these IV fluids.
On the 7th, again it boils down to RG-Cod. On the 7th of January 2025, the government said that it should not be used. In spite of that, it was being used by RG-Cod. And when the hue and cry took place in RG-Cod, then on the 11th,
we'll take it up on Thursday as the first case.
As your lordship, please.
No. Before that, you need to put the Learned Advocate General on.
I will give notice.
Thursday, first case.
My lord, I'd like to mention contempt application being number 68 of 2025. My lord, on 20th August last year, your lordship had directed the first sub-judge at Alipur to dispose of a matter within 3 weeks.
Yes, sir.
My lord, 5 months have passed and nothing has happened, my lord.
Is the court lying vacant or the
No, the court is operating and it is being adjourned.
adjourned at whose instance?
My lord, I've served the certified copy of your lordship's order, but in spite of that, it has been adjourned on different excuses.
Adjournment.
My lord, I'm seeking the.
By the learned court.
May I?
My lord.
But see that the problem is every court is loaded. Today you heard the learned advocate mention.
Yes, my lord. But
And there are a lot of vacancies. Even in the High Court, we are operating with the strength of 43 as against 72.
yes, my lord.
And there will be 2 judges in Jalpaiguri, 4 judges in Jalpaiguri, 2 judges in Port Blair. So it becomes difficult. What we'll do is from the administrative side, see, this can't be a contempt like It is a judicial order. Even an order of adjournment is a judicial order. How the High Court can say, no, you passed this order in violation. We have requested them to dispose of at the earliest. On the administrative side, I will find out what is the difficulty of the learned judge. Then we will do something. You give that paper, so RG madam can contact.
My lord, I'm seeking leave to file this.
Have you applied for certified copy?
No, my lord, this is with regard to that same issue, that contaminated saline issue, my lord.
All right, Thursday. Why do you require a leave?
But my lord, we would like to move it tomorrow.
Not tomorrow. It will come on Thursday. You file it in the department. Yes, madam.
Lordship, I am bringing your Lordship attention to the facts, Lordship. There was a circular on 16th July 1956 regarding the permission of admission of girl students in a co-educational education, Lordship, restricting the permission to admit the girl students which is situated within 1 mile from from any neighborhood girls school if situated there, or in a city, or 2 miles in the neighborhood if there is any girls school in a rural area, Lordship. The respondent number 7 institution is permitting the girls student admissions due to the guideline, Lordship. Therefore, the petitioner's institution, being the petitioner, filed the writ petition challenging the illegalities of respondent number 7 institution, Lordship. Since 2nd January, Lordship, class 9 students admission is going on, Lordship. I several times mentioned before the Honorable Justice Saugata Bhattacharya, Lordship, and his Lordship refused to accept my mentioning and not upgrading the matter for hearing of the matter, Lordship. Until and unless, Lordship, the matter is heard, Lordship, the matter will be infectious, Lordship. Then, therefore, I compelled to mention the matter today also for releasing of the matter for assigning before any appropriate bench if the Honorable Court is burdened. But the Honorable Court refused to release my application also, Lordship.
What can I do on the administrative side, madam? If it is released immediately by today evening, we can.
Yes, Lordship.
It can be assigned.
Yes.
But the learned judge has
Yes,
not
Lordship,
released the
but
matter.
my application will be infectious. What the petitioner's litigants will do, Lordship, in that scenario, Lordship? If the court failed to understand the gravity of the matter, Lordship.
You give the letter to the OSD.
Yes, Lordship, on 2nd January, I also approached before the OSD, and he also suggested me for releasing of the matter. I know his Lordship will not release my application. I requested him also, but
We can't compel a court to release.
Yes, yes, Lordship. He suggested me to approach before the court for releasing of
mentioning.
Today, I have also mentioned for releasing of that application, but he refused to release the application.
No, you should have mentioned for early hearing instead
Yes,
of mentioning
But
for
fixing
release.
it did not for only hearing, Lordship. If the matter is not heard as an urgent one, Lordship, the admission is going on, the matter will be infectious, Lordship. And the OSD also suggested for releasing of that.
Can you not file a CAN application for early hearing?
Lordship, this is motion stage, Lordship, and if hearing stage, then application is needed, Lordship. In motion stage, Lordships can fix that date for hearing of the matter, Lordship, not hearing matter, Lordship.
You give the letter, let us see what can be done.
The OSD.
Yes.
Yes.
May I have your
Yes,
Lordship
Lordship.
sign leave to mention a matter? Your Lordship, this matter was mentioned. My appeal is pending before this Honorable Court, item 39. The contempt appeared on 10. Para 3 and 4 of your Lordship. If some indulgence can be given to this matter, your Lordship.
Let us see. 39.
Yes,
We'll
your
make
Lordship.
a note.
And
Your Lordship, with your kind leave, may we permitted to mention a customs appeal matter which was previously wrongly filed in the appellate side. But your Lordship, on the last occasion, had been pleased to make necessary amendments to that to convert it to the original
Wednesday.
side. Yes, your Lordship.
Wednesday, second half. Labs. Please.
May I take the Lordship leave to mention a matter? Lordship leave may be granted to file the appeal without certified copy.
You have applied for certified copy.
Lordship, the order was uploaded on Friday. We have not yet applied.
You apply for certified copy.
Lordship, there's urgency in the matter.
No, you apply for certified copy and then mention. Today you apply, tomorrow you mention, then we will grant you.
But I am praying for inclusion of one appeal, my lord, against the residuary tender matter, my lord. But I am.
May I have my lordship's kind attention regarding a mandamus matter challenging order passed on date 5th of August 2024. Your lordship, actually it has been preferred the read petition which was been challenging regarding non-payment of compensation, and it was been mentioned under section 357A of CRPC, but as section 357A of the term CRPC has been used instead of BNSS, Bharatiya Nagarik Surakshita Samhita. That's why there is it was been mentioned as because of CRPC, the appeal is not
No,
getting
no,
registered.
which bench passed that order? Single bench or division bench?
Single bench.
Then you mention for correction. You mention for correction. CRPC. No, but if she amends the presentation form, you have to amend the presentation form. Unless you amend the presentation form, so you mentioned before the court seeking leave to amend the presentation form, make the correct provision of law, then the matter will be listed for correction.
Much obliged, Your Lordship.
Upgradation. Next week you mentioned. What to do, sir? We are trying our best.
My lord,
What is it? Group 9 matter or PIL? Let it come on Thursday. Let us see.
my lord, may I be permitted to once again this matter, my lord? This matter is in the public interest litigation form. My lord, herein in Mednapur Hospital, my lord might have heard of the news that on the 11th January, out of 4 women, one has already died due to the administration of a saline which was banned. And the same incident also happened a year ago at Karnataka, my lord. With this regard, I am praying leave to move this application before your lordship.
We have permitted. It will come on Thursday. Along with the senior advocate also mentioned same matter. So you, all right. Leave granted. Please call the list.
Program for the appellant petitioner. But not very clear why the matter is mentioned as to be mentioned.
That is what
Because no notice was given to us of any mentioning.
It will be top of the list on Wednesday when you.
Well, we had notice. No notice was given to us of
No,
any
no,
mention.
this is that pipeline.
Yes,
This
yes,
is that
yes.
pipeline. The learned advocate mentioned.
Yes.
Therefore, we said
I see.
the respondent has to be informed.
Yes, yes, of course.
We had
of course.
informed them thereafter.
So then subject to convenience, you tell some date.
Yes, my lord, because my lord, absolutely, my lord. Whenever my lord convenient, whenever it's convenient to your lordship, no difficulty. My lord, we have some urgency, my lord, because we'll recall, my lord, this is that permission was given to us. My lord, we had originally, my lord, it was a 2007 permission. In 2010.
This is post facto permission.
Yes, that's right. And your lordship asked the railways to file an affidavit. Their affidavit has now abandoned the stand they had taken before your lordship.
No, my lord, railway, my lord, we went through 3 sets of
They
joint
filed a report.
inspection.
When we pointed out how the report is wrong, in their reply, they say, we agree it's wrong.
My lord, will recall the facts, my lord. First permission 2007 to my lord, a company which went into my lord insolvency.
So fix any date which is convenient to your lordship, my lord, I have no difficulty.
My lord, the total length, my lord, is 2250 meters. Out of that, my lord, 38 meters only, my lord, goes over because they had come in later. My lord, goes over their land, my lord, the railway underbridge with my lord elevated.
Is there not a way to resolve this issue? One thing is,
my lord,
hear the appeal.
It will never be resolved because, my lord, he is the H2 bidder. He wanted, my lord, to get this Ram Swarup, my lord, industries. Yes. He was, my lord, part of, my lord, the insolvency proceedings.
That is all done.
That can't give him the right to trample over my.
He has ensured
underbridge.
Every step, including, my lord, going back there.
Lord, I don't know what my learned friend says. The trial court's trial court finding is that they have flouted every regulation known. Every regulation.
That's the appeal for. That's one of the appeal. I'll show, my lord.
Not one.
Not
Not one.
Steps. going through, my lord, all the joint
They
inspection.
wanted the company to go into liquidation.
It's only a little part, my lord, where it's, my lord, made a overbridge, my lord, a pipe, my lord, which has gone over, my lord, their railway underbridge. My lord, any day convenient, my lord, we are, my lord, ready, my lord.
The lordship fixes any date, my lord, I have no difficulty.
The water is not there, the company cannot start.
Because, my lord, it's a resolved company. My lord, unless we get the water, which is, my lord, originally, my lord, with the company itself, my lord, we can't start, my lord, our company. It's, my lord, carried, my lord, from, my lord, the Kharagpur municipality, my lord, by way of this pipeline.
But we are also having to do that because the railway refused us this permission. The river, on the ground that the river is nearby. My learned friend
But
is
that
raising
doesn't
that.
mean-
That the court has found on that also. Your lordship will
We had
find.
an existing pipeline.
But existing finished in 2017. There was no pipeline after that.
Next week.
My lord, my lord, next week, if it's possible, my lord. Thursday shooting.
We have got 2 days.
Thursday shooting. Thursday shooting, 23rd.
24 तारीख को ना।
10th February.
Well, something.
I will not be in Calcutta. I am going out for a
Earlier, my lord, if it's
ये
possible,
बड़ी-
my lord, I would
ये बड़ी-
most
No,
respectfully.
no, we were examining, it's not possible.
Any day, 2 o'clock also.
This month is not possible because
17th ठीक है तो
23rd is a holiday.
Yes, my lord,
Yes.
23rd is on.
24th, there will be a resolution.
In fact, my lord, before
But
the
even if
Peshawar-
no
Peshawar
resolution,
predicted-
Mr. Banerjee and
No, no, I am
Nice.
going to be here.
He'll
I'm
be
going to be
traveling.
here.
He'll be traveling.
No, no, my lord, I'm going to be here.
not traveling. I'll be at home, another home, and same thing with it.
25, 26. Probably you will fix some arbitration on those days.
Bullshit.
Then the week after,
17th is all right.
there may be some difficulty
I see.
for me between 27 and 29. Then
So then, my lord, 11th, my lord, then 11th February or 12th February.
11th February.
But I'm not there from 9 to 14th. Blood. तो सेटे तो तुम्हें बोल रहा हूँ. 9 to 14th.
Then 17th.
Very well.
All.
Obliged.
As jointly parade, list the appeal for hearing on 17th February, immediately after fresh cases.
Lord, some,
My lord, could I file my affidavit in reply, my lord?
my lord, preference, my lord, if it's
Affidavit
possible. my lord.
filed by the railway administration is taken on record.
My lord, obliged.
Reply affidavit of the respondent writ petitioner is also taken on record. Immediately after fresh cases, it will come. Probably 10 or 12, it may.
My lord, is it possible, my lord, to have a time, my lord, with regard to that? I'm sorry, my lord, I'm
On
making
that
that
day,
request.
probably we will do that. Suppose all of you are free at 2 PM or 2:30.
Very well.
Obliged.
All put together, how much time it will take? 1 hour, 2 hours?
My lord, we won't be, my lord, more than, my lord, an hour. 45
I'll
minutes.
take
to-
roughly that time, my lord. roughly
45
that.
minutes to an hour. My lord, maximum.
But I'll tell your lordship, there's an additional application. But after they filed the report, pursuant to your lordship's direction, we have filed an exception to the report. So that application will have to be heard out, and then the.
It's all
main
together, my lord. The
petition.
issue is, my lord, whether, my lord, the railways, my lord, had that technical,
I'm
my
just
lord,
bringing it to your
evaluation
lordship's
which they
notice
did or
that
not.
that's what will have to
Correct,
be
correct,
taken up
correct.
first.
Railway का दीजिए, हमारे
Correct.
copy दीजिए.
And, my lord, I am told, my lord, the railways has filed an affidavit, my lord. People asked, my lord, formally for a copy, my lord, if they could give us, my lord,
Their application or not, I shall supply.
No, you give copy.
a copy of the We will, my lord, get it. I'm so grateful, my lord. On the 17th, my lord.
Yes. Next.
I'm grateful.
I am not the appellate, my lord.
Why it's coming under the caption to be mentioned?
To women's, my lord.
So this order has to be, they have to be held over.
Not in the record.
The original certified copy is not in the record. Court officers.
My lord, I have suffered. My lord was there in code number 8, my lord.
But
Two
where
copy.
it disappeared somewhere, probably in court number 8.
My lord,
But
I
then
can.
this order has to be
My lord,
modified.
Xerox copy, my original, Xerox copy is with me. I can supply the Xerox copy, my lord. Xerox copy, the certified copy, my lord.
But it is a fact it was supplied. This is some police in action. What is the police in action?
My lord, it is my the expertise order, my lord. The property involved, my lord, I was, my lord, cultivated last 40 years. And on always had a private respondent, my lord, make the correction by in a fraudulent way with collaboration with the PL and LRO. Now, I paid appeal before the appellate authority. When the appellate authority delegate the matter to the SD and LRO Vishnupur. That has been heard, my lord, but order not yet been passed. The police called me, I went there, my lord,
No. The appellant was the fourth respondent in the writ petition.
yes, my lord.
Whether notice was served. If notice was served and he did not appear, it is not an ex parte. Yes. Now, in fact, the order doesn't affect your rights. What it
No,
says
no,
is-
by order of the my lord single judge, the private respondent, my lord, had took the possession, my lord. Last 40 years I was cultivating on all his heart, my lord.
This writ petitioner stated that he is the owner of a property in question and private respondent, your client, was trying to grab the property. But the police authorities have not
No,
taken
to
action. The state denied the allegation. Submits police authority inquiry into the matter and will file a report. Let the report be filed by the and they filed a report. Even after service of notice, no one appears for the private respondents. In the meantime, the police shall keep sharp vigil in the locale, ensure that no harm is done to the petitioner and family members, and no one disturbs the petitioner to conduct his vocation of agriculture. You have obtained some order from the civil court?
No, no, my lord, I paid appeal against the my record, the PL and LRO in fraudulent way, corrected the.
All right, BLLRO is not a party.
No, my lord, against that kindly, my lord. Against that, my
will
lord.
give you liberty to approach the BLLRO.
No, no, I paid appeal before the appellate authority, the PL and LRO. Appeal.
You go before the appellate.
Already I filed appeal, that has been delegated to the SD and LRO Vishnupur. Appeal has been heard, my lord. Order not yet passed, my lord. Hearing is completed. In the meantime, my lord, with the help of the police, the private respondent taken the possession of the cultivated
This
land.
order does not empower the writ petitioner to take possession. The police.
The police called me, my lord. I went there. The police told me, don't go there, let him take possession. This is the scenario, my lord.
That is not on record, sir. Now the matter is pending before which authority?
SD and LRO Vishnupur.
SD.
SDA Subdivisional Land and Land Resource Officer, Vishnupur, Bankura. Hearing has been completed, order not yet been passed, my lord. In the mean by the police, with the police, help of the police, my lord, they have taken possession, my lord.
This intra-court appeal by the fourth respondent in WPA 17941 of 2024 is directed against the order dated 24/7/2024, by which the learned single bench disposed of the writ petition by passing the following order. Sir, please quote the order. As could be seen from the above order, the appellant, who was the fourth respondent in the writ petition, despite service of notice, did not appear before the court. Nonetheless, the learned writ court has not issued any positive direction based on the allegations made by the writ petitioner, and all that has been directed is to the police authorities to keep a sharp vigil at the locale and ensure that no harm is done to the writ petitioner or his family members, and no one disturbs the writ petitioner to conduct his vocation of agriculture. The petitioner alleges that the revenue records have been illegally corrected, and as against the order passed by the BL and LRO, the appellant had filed an appeal before the SDL and so on so. Kishnapura. Vishnupur. And the appeal was heard, but till date orders have not been passed. It is alleged that based on the order passed in the writ petition, the police authorities have in fact permitted the petitioner to illegally take possession of the property. As could be seen from the order passed in the writ petition, quoted above, no such direction was issued to the police authorities. In any event, the appellant has to pursue the matter before the SD and LRO so and so, before whom the appeal is pending. Therefore, we dispose of this appeal, giving liberty to the appellant to file a petition before the SDLRO so and so Bishnupur to pass a recent order on the appeal petition filed by the present appellant, since the hearing is said to have been concluded, and such order shall be passed by the appellate authority within 3 weeks from the date of receipt of the copy of this server copy of this order. Since the SDLRO is not a party in this appeal, the petitioner is at liberty to submit a representation enclosing a copy of this order and requesting for a early decision in the matter. It will also be well opened for the appellant to work out his other remedies if it is alleged that that forceful possession has been taken by the writ petitioner. Disposed of. Next.
Grateful to your lords.
Patient is asked to trace out the original. Till that time, the photocopy shall be treated to be the learned advocate for the appellant. Has he filed a photocopy?
Sir, Mr. Lam, has he
to have a photocopy of that order?
Which is mine.
Which is mine. It has been the order is mine. Attention of the court is drawn to the order dated 16th of December 2024, wherein it has been recorded that the appellant has filed the certified copy of the impugned order. However, the certified copy is not available with the records. The learned advocate on record of the appellant is permitted to file a photocopy of the certified copy in course of this case. The department is directed to trace out the original certified copy. Till the original certified copy is traced out, the photocopy of the same shall be treated as the original.
Number 3. This is my application.
I'm opposing.
Yes.
And if your lordship kindly takes the impugned judgment, the writ petition was moved challenging and show cause notice issued under section 74 of the CGST Act. And my lord, kindly take the impugned judgment once. Annexed to the memorandum of appeal. Well, kindly take from paragraph 8 onwards. Paragraph 3 onwards. The lordship will find that the facts are stated from paragraph 3 to 7. Then, my lord, the submissions on behalf of the petitioner are noted. My lordship may kindly also note that in this matter, written notes of argument were exchanged.
Kulcha is not bread.
My lord, this is a case.
If you go to a restaurant, any restaurant,
yes,
under the caption Indian bread.
Indian bread.
Kulcha is one of them.
Kulcha is under that Indian bread.
That wrongly, you say it's wrongly classified.
My lord, we said it is a bread.
Ah.
They said it is not a bread. We said it is classifiable as bread.
That is serial number 97 of the notification.
Yes.
Does it make a distinction between Indian bread and
No,
bread?
no distinction has been made out. But my lord, that constitutes, my lord,
All
practically.
right, it's a question of fact.
No, I'm not on that, my lord.
Hmm.
That constitutes perhaps, my lord, 3 or 4% of the demand, which is leveled in the show cause notice.
Hmm.
The rest of the demand is based on, my lord, issuance of credit notes and non-reversal of ITC by the recipients of the supply. My lord, what has happened, your lordship will find from the impugned show cause notice, there are 2 paragraphs which are very relevant. One is paragraph 11, which has the heading invoking section 74.
Extended period.
Extended period. Under that paragraph, your lordship will find only the issue of kulcha has been dealt with by the adjudicating authority. Well, it is not my case before lordship that I am inviting this honorable court or the honorable writ court to decide whether kulcha is a bread or not. My case is that if it is a case of, my lord, a case of classification dispute, whether under those circumstances, extended period of limitation could be invoked or not. And when the facts are known to the party. I tell you, lordship, my lord, basic facts in 2021, sometime in the month of October, my lord, a search and seizure operation was carried out. For 2.5 years or 3 years, nothing happened. My lord, correspondences were exchanged, and my lord, we furnished all the material particulars. My lord, then in the month of August, on 3rd of August 2024, my lord, they issue a show cause notice. Your lordship will find there are 3 or 4 categories under which, my lord, the demand is sought to be raised. One category is kulcha, which is about 4 or 5 crores. The rest is all about, my lord, non-reversal of ITC by the recipients of supply when we have issued credit notes, and admittedly, we have not passed on the incidence of tax to the recipients of supplies as required under proviso to section 34. But my lord, what I am on today, if your lordship compares 11 with 12, but 11 says about kulcha. Well, your lordship may kindly take page 127 is the show cause notice. Kindly take the show cause notice for once. Because but I am proceeding on the basis, whatever facts are recorded in the facts, I am making it very clear, not the allegations. Whatever facts are recorded in the show cause notice are correct. On the basis of the facts which are recorded in the show cause notice, whether extended period of limitation could have been invoked, A. B. My lord, if your lordship kindly takes paragraph 12, my lord, which is at page, kindly give me a second, my lord. Page 171. Show cause notice starts at page 127. Kindly take from page 171 onwards. Nah, invoking me dikhana. Kindly take paragraph 11. This is a specific heading. This, I'm sorry, my lord, your lordship has got that?
No. 171.
Volume 1 of the application, I'm sorry, my lord. Stay application. My lord, the matter.
Oh, this is a compilation.
Oh, I'm sorry, my lord. This is, my lord, this, my lord. I'm so sorry, my lord. Compilation kaise chala gaya?
Compilation filed by your files.
That we had given on the, when we mentioned the matter.
It's not a compilation.
Somebody has filed this compilation.
Yes,
compilation. No.
Well, it is a case law compilation of whatever cases we cited before the Honorable Single Judge. But we will give a copy immediately to Mr. Kundalia because time is running out for us. 15th is the date fixed for hearing.
The time is running out for us also.
Well, I understand.
Because the timeline is getting over on 31st.
Well, may I take your lordship to paragraph 11 once?
171.
171 is para 11. Your lordship will find para 11 at 171.
Yes.
Your lordship will find invoking section 74. My lord, it is very important that your lordship may kindly take note of paragraph 11.1. Willful misstatement. My lord, this is the perception of the department regarding willful misstatement. Which is correct. Willful misstatement implies that there is a statement but it does not convey the information in a true and fair manner, and the statement is likely to be misinterpreted by the person using such statement. A false statement becomes willful if it is deliberate or intentional. It is not willful if the statement is accidental or inadvertent. A statement will not be misstatement only because full facts were not disclosed. Willful means intent to evade duty. So, my lord, this is how, my lord, the department sees, and this is, my lord, more or less well settled. But there is no cavil to that proposition of law. Now, my lord, this is all regarding Kulcha. Your lordship will find from paragraph 11.2, 11.3, it is all about Kulcha. Now, your lordship will kindly take paragraph 12. My lord, this is a unique show cause notice which contains a heading, namely discussion and findings.
It's not unique.
It is unique. Well, I have in my whatever
some of the okay.
Well, in the income tax, well, there may be draft assessment order, but there is nothing like draft assessment order under the CGST Act. Now, Miller, kindly take 12.1 discussion and findings. In view of the aforesaid contraventions, provisions of various provisions of GST Act 2017 and rules made thereunder, it appears that 12.1a is all about again Kulcha. Your lordship will kindly find that, my lord, kindly take from 173D. That is the major demand. More or less, it constitutes 95% of demand. And from B to D, this is all about, my lord, non-reversal of ITC by the recipients of supply, that is my distributors. My lord, it is my duty that I have not passed incidence of tax while issuing credit notes as required under section 34. My lord, it is beyond any cavil, beyond any dispute that I have discharged that duty. It is only because, my lord, this is where, my lord, the facts are slightly, I have to dispute. It is only because it is alleged that the recipients of supply have not reversed the ITC on account of issuance of credit notes. My lord, this entire liability is now being foisted upon me. And that too invoking the extended period of limitation. And your lordship will find from the language of 12.1D along with BC, my lord, C is another case of non-reversal of ITC. B, C, D, my lord, mechanically the expression suppression of facts have been used. My lord, there is no material evidence, my lord, I will stand corrected, apart from this bare allegation or mechanical repetition of the words used in the statute. There is no material evidence adduced in the show cause notice as to how and why, how and whether I have at all suppressed facts. My lord, they have gathered all the information from us. And my lord, in our returns, we have to disclose. In our returns, we have to issue, we have to show what the credit notes, whatever we have issued. And my lord, suppression of facts, interestingly, now has been defined in the statute itself. This is a peculiar case, my lord, where, my lord, they invoke extended period of limitation for X category of case. And my lord, then they invoke, and then
see, there are two aspects. One is extended period. Probably the demand, the proposed demand is only a percentage of the total.
Right.
The other one is tax liability on account
for
of
that they have also
credit
invoked
notes
extended
issue.
period. For that they have also invoked extended period.
But this show cause notice was pursuant to a search operation.
In 2021. In 2021.
But is it not a question of fact, sir?
Not at all, my lord. This is not a question of fact at all, my lord. I tell your lordship why it is not a question of fact. If your lordship kindly takes for once, my lord, if your lordship...
No, we have interfered in cases where...
My lord, what the learned judge has done, honorable single judge has done, honorable single judge has relied on a judgment rendered by your lordship. Let us be very clear about it. A judgment rendered in the case of Alok Bhomik, my lord, cited on behalf of the revenue. My lord, in our written notes, we also cited the some judgments rendered by your lordship. Unfortunate EPC International, then L&T. My lord, unfortunately, during the course of hearing, my lord, Mr. Kundalia was there. So, my lord, obviously, he will not raise any objection to that extent. Unfortunately for us, the judgments which have been cited on behalf of the petitioner, judgments rendered by your lordship where my lordship has been pleased to interfere with this section 73 or 74 scenario under 74 scenario under the GST Act or 73 scenario under the Service Tax Act or 11A scenario under the Service Excise Act. Those judgments have not even been considered. And my lordship will find extensive arguments have been made regarding credit notes. In fact, my lord, I was invited, subject to correction again by Mr. Kundolia, to my lord demonstrate as to why there is no violation of section 34. So far as my lord, the issue of credit notes is concerned, I made submissions. My lord, what the authority has done, your lordship will find it's a strange case. What the authority has done, authority has imported the concept of, my lord, reversal of ITC in case of credit notes under the category of post-sales discount as required under section 15(3) BII to section 34 when there is no reference to say section 15(3) BII in section 34. My lord, there was in fact till 2022, right? 2022, there was a provision in the statute book. These are questions of law. There was a provision of in the statute book, namely section 43, which provided for matching. Unfortunately, that provision in the statute was kept dormant. Ultimately, it was excised from the statute book in 2022. It was omitted. Then what happened? They issued this show cause notice on 3rd of August 2024, relying on a circular relating to, my lord, some remedial measure in case of post-sales discount where credit notes are issued, and the circular was issued in the month of June 2024. So, my lord, they give this circular. First of all, circular is not applicable in my case. That is my specific case in my writ petition. Your lordship will find at the end of paragraph 12.12 only. Kindly take paragraph 12. Kindly take paragraph 12. My lord, their entire case is based on this circular. At page 173, in view of the, my lord has got that. I'm sorry, my lord, 173 of the volume 1. My lords have got that. In view of the aforesaid legal provisions and circular, Britannia Industries shall be liable for taking appropriate action under section 74(1) of the CGST Act, read with relevant provisions of the HGST Act 2017, read with relevant section of IGST Act 2017 for the issues as mentioned in para. Along with that, my lord, kindly now take paragraph 6 point, first, my lord, section 34. My lord, our compilation may come handy now. Kindly take our compilation.
But there are as many as 19 plus 25 co-notices.
Yes.
Registrations.
Registrations, my lord. This is, my lord, where DGGI assume jurisdiction.
No, para 30 in they say now, therefore, all the above below mentioned 19 co-notices as mentioned.
Co-notices mean all the
your purchasers, suppliers.
No, I have, this is a case where, my lord, the case was centralized. And, my lord, different states.
Different registrations.
Yes, different registrations of Britannia. My lord,
but it's not an open and shut case.
My lord, this is a case where they have, if they have act in contravention of the language used in section 34 and relied on a circular which has been issued in the month of June 2024.
That will all be touching upon the merits of the matter.
No, my lord, I am not on that. I am simply on the issue whether the jurisdictional fact would exist for the purpose of invoking section 74(1) in a case where admittedly there was no matching mechanism so far as credit notes and reversal of ITC by the recipient of supply is concerned. Well, 2 provisions and 1 circular. That is all I will place.
See, it is not as if not a case where the authority did not have jurisdiction to issue. He is the jurisdictional officer.
He is the jurisdictional officer.
The two main issues is, one is extended period of limitation.
Right.
Then not reversing the
By Milo's recipients, I am not in control over their activities.
But you have issued credit notes.
I have issued with a rejoinder, with a note,
And
with a note at the end of.
No, the burden is on the assessee to prove that the tax burden has not been passed on.
Yes, accepted. Accepted.
Who accepted? The adjudicating authority in the show cause notice doesn't accept. Probably on reply, when you make.
No, kindly take paragraph 6.2.12 of the show cause notice and 6.2.10. Kindly give me a second, my lord. Yes. My lord, kindly take page 6, paragraph 6.2.10 at page 162.
Yes.
May I just read out? By the email dated so and so has informed, where tax credit notes are issued by us, we reduce the same from the original output tax liability. Further, in line with section 34, the incidence of tax is borne by us and not passed on to anybody else. We confirm compliance with all the conditions laid down in under section 34, along with the proviso with respect to the tax credit notes issued by us. Then, my lord, kindly take the next paragraph. It's a 162. The taxpayer has submitted the details of the credit notes issued by them for the category 1 and 3. When the supplier issued a credit note, the said details are mentioned in the GSTR 1M of the supplier. There is no mechanism to ensure what reason these credit notes have been issued. Then 6.2.12.
Yes, please.
From the above, it appears that Britannia Industries Limited has reduced its liability on all credit notes issued by them. These officers asked the three recipients whether they have reversed the ITC. They pick up three recipients of my supply for all my offices all over India, and on that basis they say, and not on the credit issued by, and they have stated in a voluntary statement that they have not reversed the ITC accumulated to those credit notes. In this situation, Britannia Industry cannot reduce their liability. Well, we have not passed on.
See, that's a question of fact, sir.
No, my lord, that's
in
an
the case
admitted
of
fact.
unjust enrichment.
Right.
So all that you need to do is, because the assessee, the burden is on the assessee to show. Then based on those documents, if the adjudicating authority is satisfied, he drops a demand.
Right.
He says no on adjudication, he says no, it has not been passed on. Then even in cases where senior has appeared in several refund cases, they say it's a case of unjust enrichment. There cannot be a case of refund.
Yes.
But facts are complicated.
Well, kindly, may I continue with 6.2.1? Well, it is their liability as they have passed on the incidents. One more opportunity has been given to Britannia to provide CA-CMA certificate in the light of para 2.4 of the circular number 212/6 of 2024 dated 26 June 2024. But the period is till March 2023. They rely on a circular of 26 June 2024, which is. Yes, well, may I just take your lordship to the circular? My lord will kindly take the circular which is in the compilation.
You please come to para 6.2.14, page
Yes, my lord.
163.
Yes, certainly.
6.2.14.
Taxpayer with a email dated so and so have submitted details tax. Accordingly, it appears that as per the data submitted by Britannia, they have passed on the credit of rupees 77.6 crores on this issue for category 1 for the period July 2017 to March 2023 for all GSTINs of Britannia. The details is as mentioned in below table. For category of credit notes issued against the invoices and other miscellaneous so and so, well, this is the detail. Well, it is.
So there is some material.
It is only the case that they have not reversed the ITC. And
Because you have reduced your tax liability based on those credit notes.
I have borne
All
that,
that
my
you
lord.
require
I have
is-
borne that.
All that you require is a chartered accountant certificate from the recipient.
My lord, kindly take for once the circular. My lord, kindly take the circular which is at.
We are getting a feeling as if we are the adjudicating authority.
No, my lord. My lord.
Joint Commissioner.
My lord, when I had a discussion with my learned juniors, my lord, Mr. Narasimhan is also here. I told that whatever happens, you will leave the court happy.
Yes, yes.
So, my lord, there is no. My lord, kindly take page 28 of the
compilation.
Kindly take the circular. If the circular applies in my case, my lord, then obviously, then also, my lord, extended period cannot be applied in the facts of this case. May I just read it out?
Yes.
In cases where discounts are offered by the suppliers to tax credit notes. So it begins with this expression. After the supply has been effected, the said discount is not to be included in the taxable value only if the condition of clause BII of subsection 3 of section 15 of CGST Act for reversal of ITC attributable to the said discount by the recipient is satisfied. So this is all about 15.3 BII, which is post-sales discount. Representations have been received from the trade and field formation mentioning that there is presently no facility available to the supplier as well as the tax officers on the common portal to verify whether the input tax credit attributable to the said discount has been reversed by the recipient or not. Request has been made to provide a suitable mechanism for enabling the suppliers as well as tax officers to verify the fulfillment of condition of, again, my lord, section 15.3 BII of the CGST Act regarding proportionate reversal of input tax credit by the recipients in respect of such discounts given by the supplier by issuing tax credit notes after the supply has been effected. In order to clarify the issue and to ensure uniformity in the implementation of the provisions of law across the field formations, the board, in exercise of its power conferred under section 168 subsection 1, hereby clarifies the issues as under. Now, it refers to section 215, which is very important. Section 15 of the CGST Act provides for the value of taxable supply of goods or services or both. Subsection 3 of the said section provides that the value of supply shall not include any discount given by the supplier, subject to certain conditions. As per clause B of the said subsection, any discount which is given after the supply has been effected shall not be included in the value of supply only if it satisfies the following conditions. I, such discount is established in terms of agreement entered into at or before time of such supply. Such discounts must be specifically linked to relevant invoices. ITC attributable to such discount must on the basis of document issued by the supplier has been duly reversed by the recipient. Accordingly, wherever any discount is offered by the supplier to the, so it is under 15.3 BI.
No, 34 also. If you read 34, subsection 2, page 12, that's clear. Any registered person who issues a credit note.
The lordship is taking section 34 now. Kindly take section 34.
Page 12 of your compilation.
Yes.
Declares the details such in the return so such credit, but not later than 30.
Where one tax mode or tax invoice
shall be adjusted in such manner as may be prescribed.
Right.
The manner clarified by the board is the procedure.
Prescribed means prescribed by the rules.
There are no rules.
Prescribed would mean.
I think you got a wonderful case before the adjudicating authority.
Kindly, my lord, bear with me, my lord. This is a case, my lord. Your lordship will find, my lord, kindly take, is there any allegation I put to myself? Well, with all humility, the question I'm putting, well, is there any allegation of suppression of fact anywhere in the show cause notice so far as this credit note is concerned, or even my lord Kulcha? Well, I could not find that there is any allegation.
Most of the cases which have travelled up to the Honorable Supreme Court have gone through the entire
Tier of
process.
appeals. Tier of appeals. Matlab,
Very
kindly take your
rarely-
lordship's order in EPC.
EPC,
Your lordship interfered with an order, not even show cause.
yes, we have done that.
Matlab, EPC, your lordship has interfered with an order. L&T has. Kindly take EPC for once.
This Naresh Kumar and company also we.
Yes.
But there was a factual finding saying that
Yes.
without any clear allegation of willful misstatement or suppression of facts of fraud.
There is no clear allegation.
There is an allegation. It has to be proved to be wrong.
Malad, who has to discharge the initial onus? The initial onus has to be discharged by the department. Malad, they have not discharged the initial onus. Malad, it is lordships have held, the Honorable Supreme Court has held, the first onus, the initial onus, or the burden is on the department, not on me. Whenever, Malad, obviously a show cause notice would contain the jurisdictional facts. Well, if there is an allegation, that allegation must be backed by some material. And this material, this onus has to be discharged only by the department and not by me. Then I am bound to answer. If they have discharged the onus as required under the law. Well, kindly take EPC for once.
In that, what is this industry? Page Naresh Kumar and company.
Yes.
Page 70, it starts at page 73 on the second issue, para 14. Middle of that paragraph, we have said, on a careful reading, about 5 lines from the top, para 14, it is evidently clear there is absolutely no whisper of any allegation of willful misstatement or suppression of fact or fraud so and so committed by the respondent necessary with the intent to evade payment of tax. In the absence of such factual finding, extended period could not be. But here the facts are complicated.
Malad, in this case, there is no allegation. Malad, it is only suppression. In a parrot-like manner, they reiterated that particular Malad phrase. Without Malad, they have to say, Malad, today if they say it is suppression, Malad, they have to say somewhere that what have I suppressed? Malad, kindly take the definition of suppression. Malad, kindly take section 74. First of all, Malad, they invoke a circular, the provisions of a circular, and for a period which is, Malad, from 2017 to 2020, and the circular issued was issued only on.
We don't have mechanism.
Malad, it is all because section 43 was never, Malad, implemented. And section 43 was omitted from the statute. Kindly, Malad, take. Malad, your lordship has also held that in case, Malad, if there is a fault or Malad, something wrong on the part of the state, something inaction on the part of the state, can the citizen or a party can be held at fault or wrong? Or the state cannot take advantage of its own wrong. Kindly take, Malad, the definition of section 74. Definition of suppression. Page 16, explanation 2. Malad has got that? For the purposes of, I'm sorry.
Page number?
16. Explanation 2 to section 74.
Yes.
For the purposes of this act, the expression, Malad has got that? The expression suppression shall mean non-declaration of facts or information which a taxable person is required to declare in the return, statement or report or any other document furnished under this act or the rules made thereunder, or failure to furnish any information on being asked for in writing by the proper officer. I've given whatever is required to be given.
Now the entire issue cropped up only after the search operation.
No, well, it is based on my return.
No. Maybe the return was processed.
Yes.
Some returns might have been processed, but this was unearthed.
No, my lord. The credit note issue was raked up much later. That was not part of the search and seizure operation at all.
There is nothing in the credit note. Absolutely. Credit note came only because of
only because of this exchange of correspondences This is not have no live link or nexus to the search and seizure operation. This show cause notice, whatever, this is actuated with the issuance of the circular.
From 21 to 24, there was no whisper about credit note in any of the correspondence.
I make this submission on instruction from 21 to 24. If June 24, if any of the correspondences would demonstrate that there was any allegation against regarding the credit notes or non-reversal of ITC, then my lord, it is a different case. Kulcha I can understand, but this has got nothing to do with the search and seizure operation. Let them cite from the show cause notice that this was also inquired into, investigated into for the period commencing from my lord this 21, that is from the date of search, till my lord May or June 2024. Nothing. So my lord, so far as these issues are concerned, these issues are not, my lord, manifestations arising out of, my lord, the search and seizure operation. The lordship kindly takes EPC now. Lordship has seen, my lord, now, my lord, suppression of fact is defined.
EPC we have seen.
My lord, suppression of fact your lordship has seen. Now suppression of fact has, my lord, is my lord, is also.
See, all these bunch of judgments.
Yes. And my lord, interestingly, my lord,
no, you can't lay down like Whirlpool, Radhakrishna Industries. They have laid down the broad parameters.
Right.
So the writ court has to consider whether it can fit in the case within one of the broad parameters, not broad. In fact, Radhakrishna Industries is fully, it is not illustrative, it is exhaustive. That decision is exhaustive.
Exhaustive.
So if I am not able to fit in the case within one of that exceptions,
yes,
then the only remedy is available is to relegate the party. This is more important in revenue matters.
Right.
That's what the Honorable Supreme. So each of these cases, EPC, this other industries, Naresh Kumar, all these issues we have gone. In fact, there are other judgments where we have refused to interfere.
Well, only one citation, which is not there in the compilation. My lord, if your lordship instructs your officers to get 2007, my lord, this is on jurisdictional fact. And to what extent, my lord, your lordship can go into jurisdictional fact.
That also we have decided in one issue, one in favor of the SSC, one against.
My lord, Arun Kumar, your lordship may recollect, 2007 1 SCC 732 or something like that, where, my lord, the question arose, my lord, the validity of Rule 3 was challenged, perquisites, Income Tax Act. Then, my lord, it was pointed out that all these jurisdictional facts may be challenged in a writ of certiorari. My lord, I raised these issues. It's a question I put to myself, my lord, with all humility, subject to your lordship's kind consideration, that admittedly, my lord, so far as section 34 is concerned, my lord, I have complied. I was not required to comply. Well, I cannot foresee, well, I am not a soothsayer that in the month of June 2024, a circular will be issued and I would be required to obtain the CACMA certificates. The circular also is restricted to 15(3)(b)(ii) issue. Section 34 only requires me, my lord, not to pass on the incidence of tax. My lord, in my credit notes, in all of my credit notes, which is part of the RUD, my lord, there is a note at the end of every credit note that every recipient of supply would have to reverse the ITC.
But 3 of them sample they have taken.
They want to see their deposition. Kindly take.
So therefore, they can be called for a cross-examination. But what? See,
even there, there are 3.
No, the intent of the circular requires to be seen, sir. Senior counsel is right in saying that it refers to page 38 circular.
Yes.
Sorry, 28.
Yes.
Discounts offered by suppliers through tax credit notes after supply has been effected. Said discount does not to be included. Mechanism for providing evidence of compliance.
Right.
So if you see the title, it is broad and general in nature, no doubt. The representation received from the trade and field formations was with regard to section 15.
Right.
But when it comes to para 2.2, there is a reference to section 34.
Right. But because my lord, section 34
covers all credit notes.
Section 34
All credit
is
and
the
debit notes.
catch-all provision.
Yes, all
It's a
credit.
catch-all provision.
15 is a
Section
subset of it.
15(3)(bii) is a
It's a subset of
species or a subset of 34 case.
Credit note can be issued for destruction of goods in my case.
It can be issued for goods return. It can be issued for any other. But in my case, it's a case.
Defective goods.
So, my lord, this is kindly take paragraph 2.7. Your lordship will find from 2.7 of this circular that this circular is limited to 15(3)(bii). Okay. Kindly take paragraph page 29. In cases where the amount of tax, yes, in cases where the amount of CGST or etc. involved in the discount given by the supplier to a recipient through tax credit notes in a financial year is not exceeding 5 lakhs, then instead of CSCMA certificate, the said supplier may procure an undertaking or certificate from the recipient that the said input tax credit attributable to such discount has been reversed by him along with details mentioned in para. So it is always restricted to, my lord, this discount and that to post-sales discount. But 34, my lord, 34 is the genus. 15(3)(bii) is one of the species of that genus.
Any sample credit note is enclosed.
Yes, RUD.
Page.
It's part of the, give me the credit note part. Absolutely, my lord. We will definitely show that. And we will also show the 3 statements. Which is part, RUD in color. Give me 1 second, my lord. Give me one.
You just show one sample.
Yes, certainly. Holding though.
436.
Kindly take page 436. I'm taking note tab.
Sir, volume 2, please.
Yes, sir. Oh, this is a declaration which we take from the recipient.
Credit note. And the credit note also. The credit
Yes,
note
credit note is there immediately thereafter.
Credit note.
These are the details of the credit notes.
Thereafter?
Yes.
Kindly take, this is the standard declaration.
It's not credit note.
The credit note be
This
here.
is a declaration.
These are declaration.
No.
Details of the
Sir,
credit
if
notes.
there is a disclaimer
Yes, sir.
or a
Disclaimer
condition,
to that.
it is for the assessee to ensure that that condition, because you have that portion of tax has been deducted from your return when you file your return.
Right.
Whatever credit notes which were issued.
Right.
But you had made it clear to your suppliers that they are bound to reverse.
Right.
So is it not the onus on the assessee to show?
But there was no system. The system.
That is where the circular comes.
No, that is where, my lord, section 43. Kindly take
The
section 43.
same issue in respect of value added tax. You remember?
Right.
The same issue arose for consideration.
Right.
What happens is he says that the purchasing dealer does not satisfy
They say we have reversed.
or does not file his return or does not pay the taxes.
436.
Well, if the lordship may kindly take
Just
the
have a look at
declaration at page 436, they have said they have reversed.
Pathak, you give volume 2.
Volume 2.
Volume 2.
Volume 2. It is we have reversed the below credit note issued under 34. In fact, the declaration says that we have reversed the ITC in respect of the credit notes.
Well, kindly take, my lord, page 436 for one.
The details of the credit notes. The credit notes copy. Details of the credit notes. And just see them. Just read them.
Okay.
Just read this. These are all the declarations.
Well, lordship will find this is by one Hindustan agencies where they clearly say
Hereby confirm and declare that we have received
credit note, we have
the below
reversed
credit
the
note.
ITC.
Then B, we have reversed the ITC to the extent
Ah,
contained in
yes.
the credit
These
note.
are all documents you can place before the authority.
But this is part of RUD.
The RUDs.
This is not, this is part of RUD, relied upon documents. This is part of RUD. This is not nothing we have annexed to this writ petition.
In fact, it is referred to in page 1138.
So
It's there in the show cause.
See, probably, let us say there are about 5,000 supplier. I mean,
About
Yes,
3,000 or
yes.
4,000 suppliers are there. Yes, recipients are there.
15 documents they might have required. 3 fellows said they have not done. All is a question of facts.
My lord, out of 3,000 or 4,000 recipients of supply, they picked up 3. And if your lordship, and my lord, then what they have done, if your lordship kindly bears with me for 2 minutes, kindly take 3 documents, my lord, kindly take for once. Just 2 minutes of your lordship time. Kindly take, my lord. Kindly take, my lord, these statements. My lord, your lordship will find from paragraph 6.2.5 to paragraph 6.2.7 or 8. My lord, 3 suppliers have been identified. Your lordship has seen that?
Yes.
Kindly take from once, page 1135.
Come to straight away, come to 1138.
Yes.
Very straight.
Kindly come to page 1138.
This is volume 4, is it?
Volume 5, my lord. Volume 5. 1138 is volume 5. But this is the basis of their case. Because this is why I wanted to show it before your lordship.
1138.
And it will clearly show that what we included in our credit note as a condition.
1138.
Well, 1136 it starts, 1138.
One of the states.
Question number 11. I will read out. Do you have made reversal? My lord has got?
Yes.
Do you have made reversal of ITC on account of credit notes issued by Britannia? No, we have not made any reversal on account of credit note issued by Britannia. Question number 12. Please refer to the credit note for return dated so and so by Britannia, wherein there is a written, it is written that there is a GST credit note and the recipient should reverse, not avail the input tax credit contained in this document under the provisions of the GST regulations. What do you want to say about this? Answer: initially my son was doing this business, and after his demise in COVID-19, I started to look after the business. I will consult my accountant and will reply accordingly.
They are saying everybody reverse.
Now, my lord, kindly take RUD 15. This is the second one. Neeraj Garg. Kindly come to, my lord, page 1143 straight away.
Not sure about question number 10.
Question number 10. Do you have made any reversal of ITC on account of credit notes generated by Britannia? I am not sure about the reversal of ITC on account of credit notes generated by Britannia. I will consult my accountant and will submit the details by Monday 5/5/24. As per best of my knowledge, we have not reversed on account of credit notes generated by Britannia. Then, my lord, RUD 16, page 1146. Question number 13. Yes.
Verbatim. It's cut, copy, paste.
Same. On the basis of these 3.
Because your products are, of course, sold to big hypermarts, supermarkets, etc.
Yes.
But there are a lot of small kirana shops.
Kirana shops.
Oh,
they are also, my lord, subject to GST. They are also, my lord, subject to GST. But these are the 3 statements which form basis of the case.
The fact is that the appeal contains 5 volumes itself is a case.
My lord, the RUD, only the RUD. This is nothing, my lord. The petition is not that.
Yes, in fact, we have
my lord, I again, my lord, at the cost of repetition, my lord, I put the question to myself. In the show cause notice, is there any material? My lord, only one judgment.
No, if you go through the adjudication process, your learned friend is there. 90% of the demand will be dropped. We know how he will handle the adjudicating.
He will confirm it.
My lord, the confirmation is inevitable. The writing is on the wall.
So therefore, those fellows cannot. They cannot. Yeah, all that they have done something, etc. They issued the show cause notice. We keep interfering with these matters. Definitely, the
allegation of suppression is absent, conspicuously absent. There is no allegation.
There is some way out. Definitely, this court will never hesitate. We have quashed show cause notices, stayed orders in original, orders passed by appellate commissioners.
Right.
And quantum is no consideration at all in tax matters.
This is
We are never, I mean, what is...
No, quantum is never a factor. Matlab, that we know. Matlab, only my lord,
The
EPC.
zeros will never ever
Matlab,
affect
no.
that process.
Matlab, zeros will only be zeros in your lordship's mind. That I know. Matlab, only one submission, my lord. If your lordship considers EPC your lordship's own
At
judgment.
times I have suffered the consequence also. That is inevitable.
That is
It's
inevitable.
my judgment, I do that.
But
It's
my
up to
lord,
them to take it on appeal.
but EPC if your lordship kindly takes.
I saw.
And they don't even.
EPC facts
Well,
are very clear.
No, my lord, it's akin to the fact. My lord, lordship has gone into the facts even in there.
Yes.
Also, they've gone into the facts of the.
My lord, today, my lord, I placed these three.
But here facts are complicated. And you are a listed company, blue chip industry, and you are a monopoly in the country. You are a monopoly. They hardly the department can do anything.
That may not go to our disadvantage. If I am a monopoly, my lord.
At times, what happens is all these listed companies are also before court. In fact, you have argued, Mr. Gulati also came and argued. Ultimately, the order was confirmed by Supreme Court. So, at times it happens because you have got a set procedure. Probably the department is not very happy with your procedure.
Well, only one
Public sector. And
well, is it possible for me that to comply with this circular for the past period?
It can't be. It's a good ground.
For it court to interfere. For it
What do you say, Mr. Kundalia? Apart from whatever we have
The
said.
circular, my lord, which has been, is in fact, the circular is more permissive to his benefit. If my lord only sees 34 2 proviso, it is very clear.
Yes, 34 second
Proviso. 34 second proviso, 34 subsection 2 proviso. Provided that no reduction in output tax liability of the supplier shall be permitted if the incidence of tax and interest on such supply has been passed on to any other person. So moment it has, he is not eligible. The moment he is taking that output tax.
What Mr. Mazumdar's endeavor is that even in the relied upon documents, there are certificates to show that they have reversed. So you have picked up 3 people, probably fellows who are not aware, and say that we will consult our accountant, chartered accountant.
On the day when they recorded, sorry,
they were not.
The day when they recorded the statement, they were not even in business with us. Those were the 3 people they picked up. They were not even. In fact, we have said so in our writ petition.
Today again, what he is going into is complete facts.
No.
And that too outside the show cause notice.
I am confining
that too outside the show cause notice is going.
I am confining myself to the argument.
Extend the time for submitting reply by another 30 days.
No, my lord, the timeline is finishing on 31st.
No,
if my lord specifically extends.
And before that, in case they want certain other documents.
Yes.
5th February.
5th February is the last date.
By which
5th February is the last
Yes.
date.
17-18.
We have to exclude the date from
Whatever
of
stay your
filing the
lordship's grants that get excluded.
Yes.
For the
The
time
petition for data filing till disposal, data filing this appeal, etc. So the court will be justified in extending the time.
Yes, sir.
By say even 60 days, because documents are voluminous. Please. This intra-court appeal by the writ petitioner is directed against the order dated 23/12/2024 in WPA 24534 of 2024. The writ petition was filed by the appellant challenging a show cause notice. Issued by the adjudicating authority.
My lord, what we can do, my lord, just to curtail the entire process. My lord, if your lordship, if we withdraw the appeal, suppose my lord, we withdraw the appeal, lordship may kindly discount the period spent in the writ petition during the hearing the writ petition. We may file the necessary reply to the show cause.
And then they may adjudicate.
Then they may adjudicate whatever. I think that will
withdraw show cause notice dated 3/8/2024. We have elaborately heard so and so, etc., etc. After the conclusion of the arguments, first, the learned single bench opined that the appellant assessee should exhaust the statutory remedies provided under the CGST Act 2017, including submitting a detailed response to the show cause notice. Decisions were referred to in support of such conclusion, and the challenge to the show cause notice was unsuccessful. After we have elaborately heard the learned senior advocate appearing for the appellant, at the conclusion of the argument, the learned senior advocate, on instructions, submitted that the appellant may be permitted to withdraw this appeal, and the time for submitting the reply to the show cause notice may be suitably extended. And as could be seen, that the writ petition was filed
How many days?
on
They have time till to.
Petition का file हुआ था?
Sir, date of filing.
मैंने September I think ना?
Supplementary affidavit is here.
23rd September 2020.
September, 23rd September. And it was decided
23rd
on
September 2024.
and decided on 23rd December 2024.
And the matter was heard, and the judgment was reserved on 9/12/2024, and the judgment was pronounced on 23/12/2024, and immediately thereafter the present appeal is being filed. Since the appellant seeks to pursue the statutory remedy by submitting reply to the show cause notice, that the time spent during the pendency of the writ petition, as well as the date from which this appeal was filed till it is disposed of by this order, has to be excluded. Instead of making any arithmetical calculation in this regard, we extend the time for submitting the reply to the show cause notice by a period of 60 days from the date of receipt of the server copy of this judgment and order. It's made clear that the court has not gone into the merits of the matter, and it will be well open to the appellant assessee to canvass all points before the adjudicating authority. On a perusal of the impugned order passed by the learned single bench, we find that the learned single bench has also not gone into the facts, but to make things clear, even assuming that there were certain observations made by the learned single bench touching upon the facts, those observations stands deleted, and the appellant assessee would be entitled to raise all contentions, both factual and legal, before the adjudicating authority.
And no factual basis was there in the judgment, only on law. He has mentioned that.
We don't know how those fellows will read. You ask your friend. Suddenly they will pick up
one
half
line, one
sentence.
word.
From one sentence, they will forget the first starting point, and they will pick up 2 lines from that and say, no. The High
And
Court
they
has
have the
said.
benefit of consulting Mr. Kundali.
No, I don't do that. I am the last one.
So, we have seen, sir. We have seen.
So my
Malad,
lord,
only one thing, Malad, the next date of hearing has been fixed on 15th. So, Malad, that may also get extended.
In the light of the above order, extending the time for submitting the reply to the show cause notice, the hearing which has been fixed by the adjudicating authority on so-and-so date shall stand deferred.
Great. So, Malad, so we go happy.
deferred and an appropriate date be filed.
He will take care. He knows what to do.
Grateful, madam.
One small question. Change of name of the firm?
No, actually, it is Lakshmi Kumar and Sridharan only. It's continuous. Otherwise, in short form, it is called as health. Sorry, this Britannia. No, he got designated lordships in Bombay High Court. The firm's name remains the same, lordships. Remains the same.
Somebody said There is another firm. So I.
No, Lordship. The firm name remains the same. Great.
What I pay for WBC DCL also responded.
But before showing the landed single judges order, kindly hear me 2 minutes time. Number the petitioner is a farmer of the pisciculture. Now, my lord, he has paid all electric bill. Now, in 2022, certainly an inspection was done by the electricity authority. Now, my lord, a provisional assessment order was given about 9,62,000. 9,62,000. Kindly see, 9,62,000. Immediately, I raised this objection before the electricity authority that I did not consume any electricity through unauthorized way. I have denied that entire allegations. Thereafter, when I give the objection, thereafter, ex parte order was passed by giving a final assessment about rupees 9,60,000. Same. This order was challenged before the writ court. Writ court ultimately found no notice was given.
But you could have gone to the ombudsman.
Appellate authority.
Sorry, appellate authority.
Lordship, 127.
No, since my lord, opportunity was not given, the writ is, there is no bar to entertain the writ petition. That's why the writ court allowed the writ petition, relegating this matter to the authority for hearing appraise. Now, immediately I filed a written objection that, look, I did not consume the electricity through unauthorized way. I have denied the allegation. Now, after that, my lord, the authority passed an order final assessment reducing the amount of rupees 7 lakh. But kindly see this order, final assessment.
Now, did you appear before the adjudicating authority?
Yes.
After filing written submissions?
Yes, I filed the written objection. After the order passed by the Honorable Court, the matter was relegated. Notice was given to me. I appear. I filed a written objection. The written objection is in Bengali. I am kindly see the written objection, page 83. Page 83, kindly see the written objection.
Now, what did the authority do? Confirmed it once again.
Hello?
After the written objection.
The order was passed.
Final assessment order has been passed.
Now, that final assessment order, kindly see. Page, my lord. Page 85. I am reading that. Submission of the consumers. Have you also got it? The petitioner representative have stated that he have committed the illegal work of theft of electricity. Petitioner appealed before the authority to consider the pilferage bill of sympathetically. Now, can you see? As per the declaration of the Sudarshan Maiti, in the course of hearing, the undersigned considered the following hours, 18 hours instead of 24 hours. Considering all the above, it is hereby passed this order with the best of the judgment that the final assessment made comes to 7,19,080.23. Therefore, there is no reason. On the basis of my submission, this order passed. I did not admit anything. Kindly see this objection. How, from which sources he came to finding that I have admitted that? Kindly see this objection. First, initial objection, kindly see. I have given this objection page 68, first objection.
But you did not appear before the authorities, sir.
I appear.
No, you have filed the objection. That is why he has used the word best of judgment.
Kindly see my objection. I go in this office.
I
This
can't
objection
understand. I can't understand.
Kindly see the.
It's an appealable order.
Page 83, kindly
Sir,
see.
we will extend the time for filing an appeal.
No, only see, my lord, only consider. These objection has to be considered. Page 83, kindly see page 83. Page 83. This objection was, I go in this office, this was received on same date, 9th January 2023, when the date was fixed for hearing. Page 83. Kindly see. And the last, kindly see, bottom, 9th January 2023, it was received. And therefore, I went there, I appeared. Paragraph 20 of the writ petition, kindly see. The petitioner went to this office. That was not denied by the electricity authority.
We will delete the cost, extend the time for filing appeal. That's all we can do.
Only one thing, kindly hear me. If this objection is not being considered, by the electricity authority. In nowhere I have not admitted this offense.
Appellate authority is entitled to do exercise all.
Only I am since this order was passed on my admission. Only I am saying let this matter be referred back to the authority.
It won't help you.
No, because I tell you lordship, because this objection.
Appellate remedy will be a more effective remedy.
No, because I have not admitted anything. Well, can you visualize this thing? I have not admitted anything. And on the basis of my admission, the order will be passed without any reason.
No. The petitioner is not a like a rustic village person. Also, he is a businessman doing physiculture, probably converting agricultural lands for the purpose of rearing fish.
Undoubtedly, we have paid this electricity month-wise. But this allegation that which I have admitted, I have not admitted anything. On the basis of which sources?
Sir, we have heard you, sir. Sorry, please come. This intra-court appeal by the writ petitioner is directed against the order dated February 24, 2023 in WPA 2007 of 2023. In the said writ petition, the appellant had challenged an order of final assessment passed by the assisting officer and station manager, Marshida Consumer Care Center, dated 9/1/2023. The order directs, the assessment has been made with best of judgment basis, and the appellant has been made liable to pay a sum of rupees 719,823.00 for illegal extraction of energy, unauthorized use of electricity by means of parallel hooking by meter bypassing in his commercial fishery premises. The learned advocate for the appellant would vehemently contend that the allegation is absolutely wrong, and in the objection given by the appellant, he has never admitted the guilt. In this regard, the objection submitted on 9/1/2023 was referred to by the learned advocate for the appellant. After we have heard the learned advocate appearing for the respondent on the above submission. The issue as to whether there has been unauthorized use of electricity by means of parallel hooking from meter bypassing the commercial fishery premises is a question of fact to be established by the appellant. Therefore, a writ court cannot adjudicate this disputed question of fact, and the appellant is not remediless, as an appeal is provided for to the appellate authority as per the provisions of Section 127 of the Electricity Act 2003. Therefore, we are of the view that the appellant should exhaust the appellate remedy available under the Act, and writ petition is not the appropriate remedy. Full stop. The learned writ court, while dismissing the writ petition, directed payment of cost of rupees 5,000. Considering the facts and circumstances, we delete the cost which has been imposed, and also any factual finding which are rendered by the learned single bench to dismiss the writ petition also stands deleted. The appellant is entitled to raise all factual and legal grounds before the appellate authority. The time for filing the appeal is extended by a period of 30 days from the date of receipt of the server copy of this order, and if the appeal is presented before the appellate authority within the time permitted, the appeal should not be dismissed on the ground of limitation, but should be heard and decided on merits and in accordance with law, and a recent order be passed.
Petitioner is poor, my lord. 1/3 amount has to be assessed, has to be deposited.
Not 1/3, 50%.
No, kindly
That is
example.
That is statutory amount.
That statutory provision is already.
I understand, my lord, I understand. He is one.
He is big fisherman, sir. Next.
Grateful, Lords.
My lord, I am appearing for respondent numbers 1 to 5.
I appear for the appellant, my lord.
What happened?
This is the intercourt appeal wherein the writ petitioner initially filed a writ petition claiming the retirement benefits of her son who has died in service. The Honorable Single Judge, by order dated 10th November 2022,
granted liberty to the writ petitioner to approach before the civil court, since the BSF authorities has directed that they have disbursed the entire amount in favor of the nominee being the appellant hearing, and further directed that a sum of rupees 3,31,261 has to be disbursed in favor of the writ petitioner. Thereafter, BSF authorities filed an application for recalling, saying that a sum of rupees 2,36,000 odd was already disbursed in favor of the nominee being the writ petitioner. The rest amount was accordingly directed. Now, I was although served, my lord, but my client was not present, my lord. Now, in the recalling application, subsequent order, which I am aggrieved, wherein the BSF authorities was granted liberty to take appropriate steps for recovery of that 2,36 amount, my lord. Now, I have talked with my client, that amount has been utilized by my client in other means. Since I was a nominee, I was not aware. Although there is a specific order specified that the writ petitioner should go before the appropriate civil court claiming her demands, my lord. Because I was a nominee, so the entire...
No. What is... Who was the writ petitioner?
Writ petition is the mother. I am the wife.
You are the wife. So the deceased was a constable in the border security force. So according to BSF, he was entitled to a total sum of about 68 lakhs. Out of which, how much was paid to the mother?
Mother has already only received a sum of rupees. She has not received anything in
one third.
She is entitled to 1/3. Learned single judge by order dated 10th of November 2022 directed that this point has to be adjudicated before the appropriate civil court, because as per the law, I am the nominee, so BSF has handed over the entire amount to me, that 66 amount. Now, my lord, the issue is, my lord, I am not on the issue whether 2,66,277, which the BSF authorities are already handed over to me. I have utilized, my lord. I am now praying before your lordship. I am ready to hand it over that amount to the BSF authorities, but kindly grant me installment. Since the order portioning, the learned single judge directed the respondent authorities to take appropriate steps against the private respondent. I am the wife. I have a daughter who is studying. Now, they have intimated virtually, orally, that unless I give that amount, they will stop my pension. That I will be in difficulty.
That will be very difficult. Huh?
So 2,66,000, what? Initially, the BSF authorities during pension.
No. How much? See, mother, wife, and minor child. 3 people are the legal heirs. Each will be entitled to 1/3. So, how much has the mother got?
Mother has got about 1 lakh something in terms, but she was granted liberty by order dated 10th of November 2022 to approach the civil court for apportionment of that. But she has not done so.
She has not done. All right. Now, as the wife, you are entitled for 1/3.
My lord.
That 1/3 was paid.
My lord.
What about the minor son?
That was also paid. I have utilized.
What is the stand of the BSF?
The BSF has thereafter, after passing of the initial order, they have filed application being CAN 1 in the writ petition, staying for recalling of that order, since they have, during pendency of the writ petition, there is learned single judge directed that 3,31,261 amount to be handed over to the mother, but they have given it to the wife. So they have filed that recalling application.
Now the mother was a dependent on the son.
Mother has an alternative pension. She is also a government employee, but she is entitled. I am not disputing that her entitlement, but that amount she has to adjudicate before the appropriate civil court. I am here before your lordship on the amount of 2,26,000. That amount.
2,66,270.
Yes, that amount only. I'm humbly praying.
So how do you say that she is not entitled to 2,66,000?
Because she has been overpaid. She is entitled to 1/3. The law is very clear after the Supreme Court judgment that nominee is only the custodian of the property. The property which the nominee gets has to be disbursed according to the laws of succession.
Correct.
Amongst the legal heirs. That has not been done.
All right. How much is she entitled to?
She is entitled only 22 lakhs. She is enjoying around 70 lakhs. She has only given her mother 50,000. That is recorded in the order.
You file a civil suit and recover.
My lord, liberty is there. for recovering that amount.
They did not make any misrepresentation. Mother did not make any misrepresentation. The deceased person left behind 3 legal heirs. As an employee, disciplined force, you are bound to disburse it in accordance with the law of succession as rightly submitted by you. The entire amount. Can you give the figures, total amount, how much?
Bhattacharyji, have you notified the writ petitioner?
We have initiated
68,64,828. That is there in the impugned order.
the can application of condonation of
Who appeared for the writ petitioner?
the writ petitioner, one Miss Indrani Pal appeared.
So server asked her to appear. Because you received that amount as a nominee, you cannot utilize the entire.
My lord,
amount.
that is my point.
At that point,
First, second, for the minor share, you also could not have utilized. How have you secured the minor's interest?
The entire amount, minor is with me.
Maybe, but how have you secured the minor's interest?
But we have entirely utilized in purchasing.
What have you done with the money?
We have purchased the property, my lord.
Now the mother-in-law and daughter-in-law are fighting.
Whose name?
Property name আছে
Because minors' education and other things are to be looked into.
She is in education, proper education, entirely.
But in whose name the property has been purchased?
That I have to ascertain, my lord.
Please inform the writ petitioner. Serve a notice.
What has happened is the double payment has been made. One to the widow, one to the mother. That is why we are entitled to return of that amount which has been made as a double payment.
In the initial,
that liberty is granted.
Initial order of 10th of.
You received the amount as a nominee. So you are only the custodian. You could not utilize
I bow down to that. The learned single judge.
If the mother her share.
No, learned single judge specifically stated that she is entitled to it, but she has to approach the appropriate civil court. But that was in the order itself, my lord.
So you are taking that advantage since the amount you have received. You could not have utilized.
But that was utilized much before, my lord.
How could you utilize that?
That was wrong on the part of the. But they have not.
How you will secure the interest of the mother?
That has been.
Mr. Bhattacharyji, take instructions.
Now, how much has to be paid to the mother?
Initially, my lord, to that.
No. How much have you to return?
68 lakhs has been paid at the initial. 68 lakhs 64,828.
How much now?
Thereafter another 2 lakhs 66,277 and 3 lakh 31,261. This is the total amount.
No. The initially, my lord, to 68 lakh 64,824 was disbursed in my favor. My
I stand corrected.
Learned single judge thereafter directed 3 lakh 31,261 has to be disbursed in the name of the mother.
In this can application?
No, in the main writ petition. During the pendency of the writ petition itself, the BSF authorities have transferred a sum of 2 lakh
66,000
in favor of my. Now
you have paid to the mother also.
Now I am ready to hand it over.
How much you are ready to hand over?
2 lakh 66,000 in terms of the order of the single judge. But I am only paying kindly direct me making some installments. That is only why.
So what did you inform the advocate for the mother and show us how have you utilized that amount?
But there was a specific direction that for filing appropriate civil suit, but in 2022 that was not done.
Mr. Bhattacharyji, you could not have utilized that money. You are only the custodian. You are taking advantage of an observation that the mother has to approach the civil court. Nothing is disputed, Mr. Bhattacharyji. you have 1/3, the minor son has 1/3, mother is entitled to 1/3. So you are illegally withholding the amount of the mother.
With that portion,
So there is no dispute. You give the mother her share. Why she has to go to the civil court?
You settle the matter, sir.
You settle the matter.
Try, my lord, we try to do it, my lord, but
Take instructions. We can give you time for return of the money you have to pay to the mother.
Issue is, my lord, since the practical situation is, since from the date of marriage between
how much time you
we are in hostile relationship. The husband also went out. Now the mother was a government.
But you cannot get
No,
more
I am
than
not,
2/3. So you have to return the money to the mother.
No,
For that, the mother.
1/3 mother
Alright,
is.
how much time you would require?
Well, with regard to these 2,66,000, my lord, I have instruction, my lord. I am ready to hand it over, but kindly grant me some installments, my lord.
Installments won't work. 4 weeks, 6 weeks, 3 weeks, 12 weeks.
8 weeks. At least kindly grant me 8 weeks time, my lord. I'm on pension. I'm only on dependent now on pension, my lord.
The learned advocate for the appellant is directed to serve a notice upon the learned advocate who appeared for the writ petitioner before the learned single judge, and to file an affidavit of service on the next date. This, how soon can you serve?
Yes, sir. Next week, kindly fix it.
List this matter in the next week.
In the admission list.
The admission list.
You can inform the advocate also.
I shall.
I'm grateful to you. At least the money which I have double paid, that has to be returned to me.
If you can settle the issue, it will be easier. Otherwise, at that age, for her to go and file a civil suit, court fee.
Mother is entitled to.
But then you should have been more careful while disbursing. Nominee is coming.
They have. I'm grateful.
Yes.
But it's my appeal, Muller. The petitioners had approached the single judge, Muller, challenging a show cause notice and a demand of penalty, which the authority had imposed upon the writ petitioner for violation of terms of a license deed, which was given pursuant to an allotment of land for 99 years. They could not finish the construction within the stipulated time, start or finish the construction within the stipulated time, and hence the show cause and the penalty imposition followed. Now the Honorable Single Judge, Muller, has decided the writ petition, Muller, as if Muller, on consent, based on a decision of the Supreme Court, where also Muller, this appellant was a party, but Muller, that decision itself records that it should not be treated as a precedent, number one. Number two, Muller, the decision of the Supreme Court relies on a pricing committee chart. Now, Muller, this pricing committee chart is of a prior date, and there was a subsequent pricing committee which revised the penal provision. Therefore, Muller, the rate which has been applied by the Honorable Single Judge is not correct application in the facts of this case. Thirdly, the case before the Honorable Supreme Court was with regard to a residential property. This is a hotel industry. Our rates as far as industry is different. That was not considered by the Honorable Supreme Court in that matter, which in any event could not have been relied on. Well, the matter needed to be gone into in the merits, whether I was right in giving the show cause and imposing the penalty. In the writ petition, my rate of penalty was never under challenge. What was under challenge was that since they are not, it was their case that since it is not our fault that there has been a delay, authority could not have imposed penalty upon us. But the rate, at what rate the penalty will be imposed, that was never the challenge before the Honorable Single Judge.
Mr. Talukdar, who appeared for KMDA, accepted the chart which was placed before the Honorable Supreme Court.
Malad, he has,
At his
Malad,
instance. At
he had
least-
introduced
No,
the order.
Bhattacharya, at least here, one fellow is ready to pay the money. How many cases there are defaults? Now, all these cooperatives, they have misused the entire scheme. And
Malad,
where is this property?
This is a hotel, running hotel from
Malad, this is just beyond, Malad,
and it's a branded
behind-
hotel.
behind
It's a
Acropolis.
branded hotel.
There's an Acropolis Mall in Koshba with a Gitanjali Stadium adjoining that. It is behind that. If I'm my learned senior will
It runs
correct
as
me.
Regenta. It's a branded hotel.
Now, Malad, this, Malad, apropos to
They
Malad, what
suddenly
fell
come-
from your lordship, Malad,
Mhm.
Malad, only this part. I'm only, Malad,
Moreover, this
that
order
one
was-
person is willing to pay. Malad, the demand is of 8 crores. The effect of the impugned order is they are to pay 6 lakhs. This is the difference.
No, you please see paragraph. In the light of the same, the petitioner herein has submitted that he is willing to make payment of 2% of the value of the land. That is 300.
That is value of the land. Malad, 1% of 3 crores is 3 lakhs. 2% is 6 lakhs. The demand is 8 crores, 1 lakh.
8 crores. You will add interest, penalty, etc.
No, no,
Malad,
not
that
even
is
that.
in terms of our pricing
It ain't
policy.
there is no method to the madness. Not even interest. There is
And
no
this
method to
order
the madness.
was passed sometime in August 2023.
Malad.
And what you are doing for all these years?
Malad, the matter was before your lordship's, Malad.
It is incumbent on them.
Malad, there's no
incumbent on
delay in
them.
filing the appeal, Malad.
It is
We were
incumbent
before your
on them.
lordship from 23, Malad. It has been, Malad,
My lord, it is incumbent on them on the basis of the license deed to come to finalize the lease deed, which they are not doing.
so those points have to be gone into. That is my
There's a
point.
specific shall there.
It
in
cannot
in the
then,
clause, which I'll show.
then from my learned senior submission is clear that the
They
matter should have,
accepted the payment. We made
That-
the payment post pursuant to
but may
this
I
order.
place my case, Malad,
made
subject
the
to what my learned senior says, Malad. If I may place my case, Malad, if that be so, Malad, the matter had to be gone into the merits. Malad, our demand of 8 crores cannot be,
This appears to be virtually a consent order.
Malad, there cannot be any consent, Malad, for to kindly seize the Supreme Court order.
Then you have to go before the single bench and say that Mr. Talukdar did not make those submissions. They were incorrect submissions.
Malad,
and-
kindly take the Supreme Court order, whether it can be relied on at all. Kindly takes it, Malad.
We will also say this shall not be treated as a precedent.
Thank you. Malad, kindly takes it, Malad. Malad will kindly take the second page, second paragraph.
Second paragraph.
Second page,
Then-
second paragraph.
Then
After the matter were argued for a considerable time and great length,
you
so
see
and
the name. That is very
but
important.
that is different. Malad. Appearing on behalf of the corporation has under the instructions stated at the bar that in the peculiar facts and circumstances, the case and without citing the same as a precedent in other cases, the corporation is ready and willing to accept the penal charge as per the minutes of the meeting of the pricing committee of so and so dated 12th February 2009. This is not applicable in our case.
All right.
Next.
Which is the pricing committee?
Malad, what is applicable to us is the pricing committee of 19th December 2009. Malad, this is residential and non-residential. We need to look into the pricing committee of industrial and non-industrial.
Right. Where is that 19th December 2009?
Copy the
Page number?
Page number.
next page.
Oh, this has not been annexed. Had never been produced also.
What has been annexed is the committee basis which this order is filed.
Yes, my learned senior is correct, Malad. This has been referred to in the affidavit, though. This has been referred to in the. Malad, kindly take, Malad, the third page, agenda number 4. Agenda number 4.
Yes.
In continuation with the earlier penal rates as fixed by the committee in its meeting dated 23rd June 2009 for extension of time for those allottees who did not commence the construction within the stipulated period, the pricing committee approved the following penal rates. Then A is applicable in our case, that in case of industrial allottees, 10% per annum compound rate. This is the rate applicable. Therefore, Malad, what was considered in Siddharth Cooperative, it was a residential property. It was not an industrial property. And this pricing committee, Malad, it is pleaded. I can show it to my learned seniors' satisfaction. This was approved by the authority meeting, Malad. That's at page 257 of your lordship's brief.
All right, what would be the relevant date on which completion certificate?
Malad, completion certificate, malad, I'll give 4 dates. Malad, the letter of allotment is on 23rd of October 2007. Malad, according to the deed of license, the construction was supposed to start by 22nd October 2009. 2 years.
Construction to start or complete?
Start within 2 years.
2 years of what? They didn't even give me the land. They gave me the land much later. License.
I'll show everything. I'll show everything, Malad. Malad, it was supposed to finish by 22nd October 2010. Sanction plan was obtained on 28th April 2010.
Yes.
And completion certificate is 4th of February 2016.
So, obviously you cannot charge penal rent up to at least 28th of April 2010. Because you obtained the sanction plan far beyond the cutoff date fixed for date of
starting.
Yes. So,
not me, they obtained the sanction plan beyond the time.
Everything from them. All permissions, everything is from them only.
Malad, sanction plan is by KMC, Malad. We all know that. Malad, let us not go into that argument. Sanction plan is by the corporation, Malad. We are the development authority. But all the government authorities cannot be put in the same basket, Malad.
No, according to you, he has to pay penal interest from 22/10/2009 till 4/2/16.
No.
Malad,
According to him,
Malad,
it is
with effect from 21st January 2011,
5 years of
21st December 2015.
Wait, please, once again.
21st January 2011 to 21st December 2015. This is what we calculated while issuing the demand notice.
That is 8 crores.
That is 6 crores 96 lakhs, 95,000. Then service tax, Swachh Bharat cess, and Krishi Kalyan cess. Which adds up to 8 crores.
Service tax has not been dealt with by the...
No, my lord, before that, my lord will kindly see the license deed. And there are a lot of things. They are presuming that this pricing committee will be effective here. So my lord will also have to see.
This point has
And
to be
on
gone.
this basis, when they were losing the matter, they came up with, at that point of time, in fact, I was there, on the trial, when the trial court passed this order, when the order was going against them, they came up with this Siddharth cooperative, and they said, my lord, this is kindly.
But
So it is,
his point is, the Siddharth cooperative was for...
my lord, for a moment, my lord, for a moment, doesn't take Siddharth cooperative. I'll come to Siddharth cooperative.
No, then you agree for 10% commercial rate.
No, I have never done that. My lord will see the license deed first. Doesn't talk about penalty.
Termination.
My lord will kindly see page 87. My lord will kindly see.
Oh, this penalty is a brainchild of the pricing committee.
Yes. And that also, my lord, I'll show how and what.
Ratified by the authority meeting.
My lord will kindly.
Authority meeting is within yourself.
Yes.
You have to obtain their consent.
Nowhere this consent. And that
going
apart.
by that, then it is a purely contractual in nature. Everything has to be guided by the license deed. Then the REIT itself will not be maintained.
No. If he has not completed the construction by 22nd of...
Start, kindly cease, my lord.
Start, assuming
he did not commence construction. My lord, the language is, who did not commence construction.
Cancel the license. You didn't do that. Yes. Thereafter, he applied for...
Then, my lord, kindly allow me to place the dates, my lord. I'll make it, my lord. I have all the dates, my lord. My lord.
No, if the license deed does not provide for levy of penal charges,
yes,
it is without jurisdiction. And the best thing is, we will go by this Siddharth cooperative, which in fact, Mr. Bandyopadhyay is a consent order, sir.
Yes.
Well, in Siddharth cooperative is a consent order.
Yeah.
Well, Siddharth cooperative and the pricing committee is not applicable. It is a industry, it is not a residence at all. Siddharth Cooperative was a residential cooperative.
But then if this recording is wrong, you could have filed a review.
But along with that, that refers to an older pricing committee applicable to Siddharth Cooperative. One of the facts of, without going into the facts of Siddharth Cooperative, it could not have been relied upon at all.
So therefore, we keep Siddharth Cooperative aside. We go by your license condition. License condition does not permit you to charge penal interest.
Then it permits us to deduct 20% of their deposited amount and termination. But they are not accepting that.
Then you should have exercised that right at the first instance in 2009.
Yes.
Allowed this person to get a sanction plan in 2010. Completion certificate, he took 6 years.
We gave show cause. They replied to it.
You didn't.
And it was discussed in the authority meeting. Kindly allow me to place the papers, Malad. Kindly allow us to place the papers, number one. And number two, Malad, the license was executed, Malad, 28th April 2008. 28th April 2008. And there was no fixed timeline in the deed of license to execute a lease deed. The question of not giving the land does not arise. It betrays their pleadings.
So, in Siddharth Cooperative, the allottees voluntarily agreed, we will agree to the pricing committee resolution. Therefore, keep Siddharth. He says, no, I was not put on notice. Therefore, you will have to fall back on the license condition. If the license condition doesn't permit, right. But as of now, by this KMDA submission says that KMDA has accepted the above table for charging of penal interest and evidence so and so. Therefore, the particular case on hand falls in category extension up to 5 years, for which penalty has to be paid at 2%. In the light of the same, has submitted, he is willing to pay 2% of the land value and directed to pay.
Then can I take the last paragraph of that page? However, it is observed that the present order is passed in the peculiar facts and circumstances as per the consensus arrived at between the learned counsel appearing for the respective parties, and the same shall not be cited as a precedent, and question of law, if any, is kept open. And same again, Malad, as far as the other appeal, Malad, other SLP was by KMDA against another party. Both appeals were taken together. Same observation, your lordship will find internal page 5, last paragraph. We make it clear that the order is passed in view of the consensus between the learned counsel regarding so and so. It shall not be treated as a precedent.
But here we'll keep the Supreme Court order separate.
Yes, well,
from what we can see in page 3 of the impugned order, it is clearly a consent order. First paragraph, third paragraph, in the light, fourth paragraph, in the light of the submissions made by both parties, petitioner directed to pay payment of 2% of so and so within a period of 5 weeks. In the light of the above discussion and observation, show cause notice was set aside on the understanding that the petitioner will make.
Well, may I read that first paragraph of third page again, Malad? What the learned counsel merely submitted was that KMDA has accepted the above table before the Supreme Court as the basis of charging penalty.
So therefore, the submission should have been, in this case, sir, we will not accept it because it's a commercial property, XYZ, second pricing committee of 2009 will be applicable, except those arguments are not there. Where is your affidavit in opposition?
Yes, Malad. Kindly takes, Malad. My opposition is starting from 186. Kindly takes my specific pleading with regard to the pricing committee, Malad. Malad, I believe, Malad, in my understanding, Malad,
Malad, in that order also, if my lord sees the second paragraph,
kindly, Malad,
specifically said, several judgments have been cited on behalf of both the parties, and the court was on the verge of passing a judgment on the issue, which is a fact. That is when, on that last date, when the judgment was going to be passed,
196.
This was shown by the council.
196
and then to cut the whole thing short, we said, okay, if 6 lakhs is the thing, we'll pay.
Yes, but 8 crores cannot be brought down to 6 lakhs, Malad. That is also without any basis. Malad, kindly takes paragraph N and O at 196. 196, Dada. The Land and Flat Allotment Committee of Answering Respondent, KMDA, in its meeting of 9th meeting so-and-so as proposed in Agenda 6 for imposing penal interest for extending the period time, the effect that the allottees in that case of so-and-so and also in bulk land often pray for extension of time beyond the specified time for commencement as also completion of construction within the considered case-to-case basis. Presently, there is no provision for imposing and or charging penal interest for extension of time beyond the normal period. Imposition of penal interest for extension of time
which is correct.
Then my lord, kindly takes O. Subsequently, in 159th meeting, authority held
Only 2 minutes. License shall be taken. By conduct the determined. The pricing committee, that is what he says. A flat allotment committee answering respondents also 9th meeting. Agenda imposing penalty for extending. What was being argued here was not argued before.
no, my lord, may I show paragraph O, my lord?
See.
O.
Page 88 of the license lease deed says that he has to complete the project within 3 years from the date of issue of allotment.
Allotment.
If he doesn't do it, what you can do? License terminated with deduction of 20% of the premium was paid by the licensee as service charge. Remaining amount shall be refunded without interest. You did not exercise the right. Thereafter, 2 pricing committees took a decision. Page 196, paragraph N and O. So, if the allottee, admittedly the allottee did not comply with condition 4.3. Page 88. Now you are trying to take advantage of the pricing committee's decision for extension.
No. My lord, you see the show cause notice.
No, otherwise where do you fall on? There's no power.
Because they have waived that. They have waived. My lord, if my lord sees, they are saying that allotment was given in 2007. They are saying the license deed they entered into in 2008. Today the possession has been given in March 2008. So by that count also 2 years comes to 2010. So my lord, thereafter there are several documents which we had annexed in the opposition also, that there was a 7.5 meter road only. The hotel required a 9 meter road minimum. So plans had to be changed because of that. It's not a question where we have dilly-dallied with the whole thing. It has been continuously going on. Thereafter, fire license, etc. were taken. And then they allowed us to do the construction. We gave the sanction plan. They allowed us to do the construction. We constructed. And the minute we started the soft launch project from 2013 onwards. Thereafter, KMC made the different changes and came. Ultimately, completion certificate was given in 2016, which we had applied for in 2015. Which we had applied. No, I'm saying it. In 2015, we filed for the completion certificate or with all documents. 2016, KMC gave us the. By that time, the hotel was in full. Had been constructed. It was in full operation, and that it has been continuing operation from 2016 till now. Now, my lord, we'll see the show cause notice. Page 146, my lord. Page
146 is show cause.
My lord, kindly see the show cause. What is the show cause notice? My lord, they give the show cause notice to us when? 24th November 2015. That is again after I had completed everything and given the KMC all the documents seeking the completion certificate. Now, my lord will see, whereas according to conditions of clause 2, subclause 3. 146. No, my lord, whereas it has been verified from records that plot number so and so, category bulk land under so and so was allotted to Sen's Group void the office allotment letter dated so and so. My lord will see the date of his allotted letter, 23/10/2000. And my lord will also notice is bulk land. And whereas possession advice was issued on 21st January 2007, and whereas license deed was executed on 28th April 2008 in respect of plot number so and so, at so and so. And whereas according to conditions at clause 2(3) of the license deed executed on 28th April 2008, the allottee was supposed to complete the construction within 5 years from the date of execution of license deed. But it has been seen that the allottee has not submitted completion certificate, so he is asked to show cause as to why the allotment will not be cancelled as per the existing clause of license deed for non-construction within a scheduled time. So this was the, so they themselves are saying 2000 from April 2008 to 5 years, which comes to 2013, according to them. This is their case that you have not completed the construction within 2013, and therefore you are why action should not be taken against it. Now, my lord, will
Now, if
kindly
the
see.
penal charges are calculated at 2%
Yes.
for the period from 21/1/2011
Yes.
to 21/12/2015, how much does it come to?
5 years.
It comes
In quantum.
From 2000.
You please take page 233. That is the demand.
Yes.
That 2% is not compound. I am only indicating. It's simple interest.
What do you indicate? Read. My lord, yes, 233.
Penal charges for completion delay within bracket with effect from 21/1/2011 to 21/12/2015 at 10%.
This determination date is wrong. They themselves it is wrong, which is what I am showing.
What did you agree before the date of the writ court? What was the determination date you agreed?
We agreed to 2013. We agreed to 2013.
5 years.
So 2013, 5 years, even if they take it as that scope to be within 5 years, I am completed and started my completion certificate was given on 2016. So 3 years period is there. It is their case only.
No, they have pushed back the date of completion from 22/10/2009 to 21/1/2011. That is very reasonable. Otherwise, you would have lost your allotment.
My lord, what
Sir,
date?
you should have completed the construction by 22nd of October 2009.
No.
10.
5 years from 2008 comes to 2013. I was supposed to complete the construction from the time the license deed was given to me. We entered into the land, and in 2013 we were supposed to complete. Within 2 years I was supposed to start, and within 5 years I was supposed to complete. That's their case, admitted case also. 2 plus 3, 2 years for starting the construction, and 3 years for completing the construction. My lord.
No.
Yes, allotment in October 2007.
Allotment 2007.
Yes.
License deed possession was given to us in 2008.
5 years from 2008.
5 years from 2008.
3 years.
So it comes to 2013. And I gave the completion certificate in 2016. So for me, there was a delay of 3 years. Before that, they gave me a show cause notice that you have not completed. In fact, when they gave me the show cause notice, I had already completed. Now they are basing that you have not completed. Therefore, they come to a conclusion with a demand saying you pay 8 crores for something which is land worth 3 crores. Worth 3 crores. I have paid 3 crores.
All right. Accepting your case from 2013 to 2015.
Yes.
Till you 2016. Till you obtained completion certificate. You are bound to compensate.
That's what we have done.
Now let's
I won't have. There are other issues. There are, because I have showed in the adjudication that the delay was not attributable to me. This was what was argued also. An order was being passed in our favor. At that point of time, in desperate situation, he showed this judgment, saying this is the formula that is being taken.
Now, between 2000, according to you, from 2013 to 2016.
Yes.
If it is calculated at 10%, what will be the penal charges?
If 10% on 3 crores will be 30 lakhs and 90 lakhs.
And how did they make it as
That is there's no method to the madness, which is what I started with, my lord.
Oh, at the rate of rupees 40 lakhs per quota.
Yes.
Where did you get this 40 lakhs? That was not the agreement.
No. Agreement was 8 lakhs.
No, in order to purchase peace.
On current value. They have gone on the basis of current value because the pricing committee says so.
No, you should calculate on 2 crore 91 lakhs 22,000. That will be the consideration which was paid by the licensee. So we can round it off to 3 crores. On 3 crores, you pay 10%.
No, but that I am not agreeable to, my lord. My lord will kindly see. My lord will kindly see.
You are now they will not execute the deed of conveyance or lease deed. You can't get the property assessed. You can't do development. It is a prudent business practice.
My lord will kindly look at the pricing committee.
Sit at 10% of 3 crores.
My lord, kindly see the
value.
My lord.
I am also not agreeable. My lord. Since I have not got the opportunity, I am not saying anything.
All right, admit.
No, my lord, only one thing, my lord.
Prayer for stay refusal.
My lord, before my lord admits, my lord gives me 2 minutes.
No, we'll keep the appeal pending. That's all. We have heard so and so, so and so. Prime facie, in our view, the impugned order appears to be a consent order between the parties. The submissions made by Mr. Bandapatiya before us, based on the averment set out in the affidavit in opposition filed in the writ petition, appears to be never canvassed before the learned writ court. And the contention of the appellant is that the order cannot be read to be a consent order. As observed above, in our prima facie view, it appears to be a consent order. Therefore, all that we can do is to entertain this appeal, but prayer for stay stands refused.
My lord, only one thing. Only one thing. If this matter can be resolved, because till then, they will not finalize the lease.
Very difficult.
So, my lord, if this appeal can be taken up, give it.
Your lordship will find.
We will, if you can purchase peace with them, after all, they are a government body. You have some discussion.
No, discussion. There are. My lord,
the honorable single judge has held that if they do not pay the 2%, I am entitled to charge 15% penalty on them. So, my lord, the honorable single judge accepted my power to impose penalty.
That 40 lakhs per kata you can't do.
But it is on the pricing committee says current land value.
Now, my lord will only see one page.
So therefore, we round off the amount as 3 crores. 10% of 3 crores he will pay.
My lord, page 185, my lord sees the interim order passed at that point of time. My lord will kindly see just one paragraph of that. 185. A demand notice dated so and so issued by the Assistant Controller of Finance and Accounts, Kolkata KMDA, is under challenge in this writ petition. By such demand notice, 8 crores odd was demanded from the petitioner as penal charges for delay in construction service tax thereon. The demand notice does not refer to the source of power which was sought to be exercised. The bench was inclined to set aside the demand notice with liberty to the KMDA to proceed afresh. But since Mr. Basu, learned advocate representing the KMD, seeks an opportunity to file the affidavit in opposition, affidavits are invited. Then affidavits were called for. Then there's the last paragraph. The demand notice shall remain stayed until further order. This interim order is passed based on the prima facie satisfaction that the source of power exercised by the assistant controller has neither been indicated in the demand notice nor any provision or clause conferring such power has been brought to the notice of this bench.
This committee.
And thereafter, if my lord sees the document that was shown to my lord, the document that was shown.
No, Mr. Kondalia, the problem is, even now they can, if we hold that this pricing committee decision, etc., is beyond the pale of jurisdiction, cannot be enforced, they can still now enforce the terms of the license. And if they re-enter the property, probably they'll calculate the compensation for superstructure at pittance.
May I read one line of the demand notice, my lord, for everyone's convenience? One line.
The document that he placed before my lord, this relates to Kona Expressway, not this area.
May I read only one line, my lord, for my learned seniors' convenience also? In the last line of the demand notice, within 36 days from the date of issuance of this letter, or allotment shall deem to be cancelled if payment is not made. So this payment is in lieu of extension. This payment is in lieu of extension. They may not pay.
And my lord will see 260.
No, it is reasonable you accept something. Probably we will not sign this order for 3 days.
My lord then keeps it next week.
No, this order we already dictated. It is on record. It has gone live. It can be. All that we can do is we will not sign it for 3 or 4 days. Meantime, you discuss with your client because it's a commercial venture.
My lord then keeps a liberty to mention.
No, nothing. We will not sign. You transcribe, keep it to you. Then when Pathak will tell
So my lord has given this suggestion that if we pay 90 lakhs and they accept that 90 lakhs, then they should.
No. What we can do is we cap the penal charges at 10%. 10% on what amount? Prime facie, we are of the view that 40 lakhs per kata cannot be imposed on you. But nonetheless, this is sort of a concession given to you.
1 rupee. Lease is 1 rupee for 99 years.
So therefore,
he's saying 1 rupee today. In a God-forsaken, how much money we have also paid? It's not that he has given for 1 rupee.
Premium is 1 rupee.
Lease deed they have not entered into yet.
There is no timeline.
The money that has today in a God-forsaken place completely where I used my own invest, my lord, I have annexed the bank documents also. I have to pay extra interest because it's only a license deed, not a lease deed. That extra amount of 3% extra interest that I've been paying for the last so many years, who will bear that?
Then relegate us to the civil court. We'll also adduce evidence whether it was their fault or not. We'll go before the civil court.
Lord, before my lord's rise, may I just, in the next matter, item number 7 to 12.
7 to 12.
These are matters already admitted, interim order has been passed, but it has come wrongly under the heading admission.
Okay.
But item number 13 is a similar matter. A similar order may be passed in terms of your lordship's order dated 29th April 2024.
I am appealing for the respondent.
29th April 24.
It was mentioned by me, these matters. One matter, your lordship said that all matters should come together.
Club together.
I have given that list because, my lord, huge capital of these exporters after fulfillment of exports are blocked for years together. Your lordship has passed an interim order. We were hoping for hearing of these matters. These are all similar issue of a license.
Very well, Miller, kindly fix it up.
We can fix it on 2nd week of February.
Yes.
Whatever your lordships deem fit.
Let us see the interim order which we passed.
Miller, yes.
আমি কপি দিলাম এক্ষুনি
Copy this.
কপি দিলাম দুটো কপি দিয়েছি
You know, 29th April 2024, delay was condoned. Interim order of stay till disposal of the appeal. Para 6 of your lordship's order.
দিলাম না
In this item 13, this appeal shall be heard along with MAT number 304 of 2024, etc. Following the interim order granted in those appeals, there will be an order of interim stay of the impugned order in the writ petition dated so till the disposal of the appeals. Let the appeals be listed for hearing immediately after fresh cases on when it can come, sir. Then we have fixed the other matter. That is 17. On 10th February.
Because the item number 13 is a similar matter. Similar order may be passed.
Yes, passed.
Item number 13.
Passed.
My lord, in the meantime, my lord, may I request my learned senior appearing opposite, in the meantime, to serve us copies of these appeals. Because they have only served me one appeal.
All right.
My learned junior will serve.
Yes, Pandey, you serve. The learned advocate appearing for the appellant shall serve copies of the appeal petition, stay petition, annexures, etc. To the learned advocate appearing for the respondents within 2 days from date.
Let's.
30. That is.
Yes. Item number 13, similar order may be passed.
Is passed. Lad, item number 23, lad, I mentioned this matter, lad.
We'll take it up after lunch.
After lunch. Mr. Bhattacharya is I'll
Shamim, you can manage it.
10th February. My lord has fixed these matters on 10th February.
My lord, may I have your
So
lordship?
we will continue from 14.
Yes.
Second half.
My lord, may I have your lordship's leave to file, my lord, without certified copy? My lord, this was mentioned today in the morning, my lord. My lord, impugned order is dated 8th of this month, my lord.
Yes.
On 10th, late in the evening, my lord, the server was made. My lord, today we have applied for certified copy.
Yes. Morning, when your colleague mentioned, she did not apply for the certificate.
I am for the appellant. This is the affidavit of service.
Service complete or it has returned?
As regards service upon the Board of Councillors of Bali Municipality, who is a party respondent hearing, that has been refused. As regards respondent number 2, who is one of the main respondents, that is the Cattle Licensing Authority, that envelope has been returned back with an endorsement that left no such person in the such address. I guess that when the representation made, that has been served. Later on, any representation or any service of notices has been returned back with no such person in that address. So I guess that particular designation is in the nature of personal designator. Unless and until I state, if appeared state may confirm this.
But who will appear for the state? In the writ petition.
I know state has been served through government leader office also, and also.
What was your prayer in the writ petition?
My lord, prayer is that
to illegal cow shed.
Illegal cow shed, and the point involved in this appeal is that whether the statutory authority is restrained to do its statutory function if there is any order of status quo in the nature and character of the suit property is pending between the private parties in a civil suit. The impugned order, as per the impugned order, my lord, the learned writ court held that since there is a civil suit pending between the petitioner and the private respondent, although it is admitted that there is an illegal fatal is running in the property concerned, but since there is a recovery of suit for recovery of is pending, filed by the petitioner against the private respondent, wherein an order of status quo in the nature and character of the suit property is pending, the remedy lies before the civil court. I am challenging such finding of the court.
The status quo is regarding immovable property.
Yes.
In the immovable property, there is a cow shed, which according to you is illegal. But if the civil court has granted a status quo, it means status quo in respect of the entire extent, including the cow shed. How police can or the licensing authority?
My lord, I have two submissions, my lord. My prayer before the statutory authority is to removal of the cow, because running of cow shed in the municipal area is barred by the statute. And the authority is concerned, there is an earlier writ petition, my lord. If you will also kindly look at the page number, the earlier order passed in the writ petition, kindly look at page number 64 of my application for appropriate order, Can 1. That is the order passed in earlier writ petition, where the writ court, upon perusing the report filed by the Bali municipality, it is held that there is a hatal running 10 feet in 10 feet and granted liberty to the petitioner to approach before the cattle licensing authority for taking appropriate steps.
So to that extent, the cattle licensing authority can do. But if suppose he is running it without a license, they can issue a show cause, etc. Your prayer is only that?
Very well. No. In the present writ petition, I have made representation to both the cattle licensing authority as well as the municipal authority, because both the statutes under the municipal law.
Where is it? Please show us that representation.
My lord?
Representation.
Representation. Page 66, my lord. Page 66 is my representation, my lord. And that has been duly delivered before all the parties. Being inaction of that, the present writ petition is filed.
You are the plaintiff in the suit.
I am the plaintiff in the suit. I am the plaintiff in the suit.
In the suit, is there any, or in the written statement, is there any pleading regarding the cow shed?
They are storing cows illegally. That has been pleaded.
In your plaint?
In their written statement. One thing I am submitting, my lord, if you also kindly appreciate, that order of status quo granted by the civil court to protect the interest of the suit property. Now, by grab of it, if anyone can do a wrong thing over the suit property, that is always the statutory authority's power to stop such illegal thing, which is to the extent that the statute prohibits. The running of khatal illegally without license within the municipal area is prohibited by the statute.
And what happened to your representation at page 66?
That has not been answered by anybody, and that therefore the present writ petition is filed.
That was dismissed.
That was dismissed, holding that.
But then without the license, they can probably they can find out the conduct inspection whether the cow shed is running with the license. That the notice sent to Bali municipality has been refused.
Municipality notice sent with the name of municipality, that has been received. But since the municipality is not yet in functioning, so I think the pending the notice sent with the name of board of councillor, that has been returned with refuse. But the
Anand Banerjee represents Bali municipality. Inform Mr. Banerjee.
By today or keep it by today, or
we'll keep it on Monday. By then you inform. Please.
The learned advocate for the appellants submits that the notice has already been served upon the respondents. However, none appears for the respondents. So the learned advocate on record is directed to communicate the next date of hearing to Mr. Anand Banerjee, learned advocate who usually represents the Bali municipality. The learned advocate is for the appellant is further directed to inform the learned advocates who represented the state before the learned single judge. List this matter next
Monday.
Next Monday.
In the admission list. Yes.
Next Monday.
Also bring the copy of the plaint and the written statement of that.
On the next day. Item number 15.
Lord, this appeal is, my lord, at the instance of the state.
I am appearing on behalf of the respondent. I am being led by Mr. Lakmani. He is virtually appearing.
Yes, I'm appearing for the writ petitioner.
Yes.
Who's the respondent here? I'm sorry, my lord, for not being there physically today.
No, not at all.
My lord, here, my lord, there is a difficulty, my lord. I do not know how to express. Mr. Lakhani is also there. My lord, your lordship's pleasure was to observe on the first day that we should go back before the learned single judge. Now, we have applied before the learned single judge, but somehow, my lord, we could not, my lord, get the matter heard before the learned single judge. It's in the list. Now, so far as the interim order that my lords have been pleased to pass on the first day, that is been extended from time to time. On that, I have no.
Can you not mention before the?
In fact, we had mentioned, they had mentioned, but rest I cannot say.
My lord, my only request is, if your lordship would just give one polite reminder, my lord, to the learned single judge, I think that should, my lord, help us. Because, my lord, my passport, my lord, I am, my lord, a member of the Legislative Assembly of Jharkhand. My passport is held up, my lord, with the authorities. I can't undertake a single journey, my lord, beyond the shores of this country. That apart, my money also is held up, but then that's, my lord, a secondary issue. Passport, my lord, is of prime importance.
But what we can do is, since it's felt from your lordship, I don't want to embarrass either the single bench or the division bench. I'll make another mention, my lord. Kindly keep it on next Monday. In the meantime, tomorrow or day after tomorrow, I'll make a mention before early edition.
The interim order is extended till January.
Yes, it's.
We have heard the learned advocate general appearing for the appellant and Mr. Rachit Lakmani, learned advocate, appearing for the respondent. Reference may be made to the order dated 25th of September 2024. Wherein, among other things, liberty was granted to the appellant/state to move the learned single bench for appropriate clarification. It appears that the appellant state has filed an application which is now pending before the learned single bench. The learned Advocate General submitted that he will mention before the learned single bench seeking for appropriate orders in the said application and request this matter be adjourned. List the matter on 20th January in the same position.
Very good. I'm grateful.
I'm grateful, madam.
Well, I am acting always the appellate. Appellant is a BSNL authority, my lord. If BSNL entered into a contract with the respondent number 1 and respondent number 2 is the proprietor of the said company, my lord.
It won't follow. But is it a group 8 matter?
No, my lord. It is a group 9 matter, my lord. Residuary matter, my lord.
No, where is your presentation form?
Within the
writ petition.
In the writ petition filed by the respondent number 1 and 2.
What is the classification they have adopted? If it is group 8, it will take that channel. Suddenly, how do we take it out?
Well, it is a residuary matter, man. It is a contractual obligation between the respondent number 1 and 2 with the appellant, my lord. But appellant entrusted some portion of the work to the respondent number 1, which respondent number 1, and which respondent number 2 is the proprietor of the respondent number 1. My lord, they did not complete the work. My lord, they preferred a writ petition before this honorable court, my lord. The Honorable Justice Rai Chattopadhyay, at the time of hearing, my lord, on 9th April 2024, give an opportunity to disclose the fact. My lord, we disclosed that we have sustained, they did not complete the work. They did not complete the work and file the bills. The bills must be attached with the completion certificate, AT, alternative testing report, and other documents. Factual aspect that at the time of they discussed, but the honorable court attached kept with the record, my lord. We have served the copy of this problem to the petitioner, my lord.
But the problem is you didn't appear before. Nobody appeared for the appellant before the writ court.
We have appeared. My lord, kindly 2 orders, my lord. My lord, first day, my lord, we have appeared. We have disclosed the documents. My lord, kindly look into the order dated 23rd April 2024.
Now, what is the dispute? You have issued the completion certificate.
No. Completion certificate has yet not been issued. They raised bill. Factual aspect that in the agreement, there is a clause of arbitration, my lord.
No. In page 91, second paragraph, the learned judge has recorded that after completion of the work, the respondent authorities have issued completion certificate in favor of the writ petitioner with respect to the work.
No, my lord. No scrap of paper completion certificate is not there.
Where is your affidavit in opposition?
We have not filed the affidavit opposition, my lord. We raised the point that there is an arbitration clause in the agreement.
Sir, no.
My lord, kindly look into the.
If I may be given a chance to speak, Your Lordship, this is an application under Group 8. Here is the category under the case status. If I may be allowed to send.
Also, the similar issue had arisen the previous time.
After completion, my argument.
If I may, Your Lordship, the previous time under before Justice Debangshu Boshak's court as well, in his order, he noted these are his observations that it was listed under it is an application under Group 8 and has been wrongly listed under Group 9.
Same order is here, madam. But if you see your memorandum,
yes,
your presentation form,
yes,
it says Group 8, Subgroup 5.
That wrongly done, my lord. It is done by the clerk, my lord. We have signature.
You have to amend it.
But give me liberty, my lord. Now and then I amended the same.
And you please see the impugned order.
My lord, impugned order is that, my lord. Kindly look into the. Memo of appeal, my lord. Last portion, my lord. 9/4/2024. There is a two order, my lord.
There are two orders. This appeal has been preferred against which order?
My lord, first letter order, my lord. 9/4/2024.
Until you challenge the 9th April order, which is an ex parte order, in the sense you didn't appear.
My lord.
Sir, please come to page 89. Please come to page 89.
Yes, my lord.
Nobody appeared for the respondent.
My lord, for that reason, I mentioned the matter before the Honorable Court.
No, unless and until.
My lord, we have challenged.
Where have you challenged?
We have challenged, my lord. Kindly memo of appeal, my lord.
You can't. You have challenged the 23rd of April 2024.
No, my lord. My lord, we have challenged the both order, my lord.
You can challenge it in a single appeal.
My lord, then, my lord, I am challenging the order dated 9/4/2024, my lord. My respectful submission, my lord.
No, you are appearing for the respondent.
Lord, we are for the respondent.
You please show the completion certificate in respect of both the contracts.
My grateful, my lord, I shall. Lord, this is, my lord, subject to correction. In page 42, my lord, of this is, my lord, the application, the stay application, my lord, in MAT 1436, my lord.
No, you please show us the completion certificate, because in the order passed on 9th of April, the learned judge has recorded that completion certificate has been issued. Now BSNL is before us contending no completion certificate has been issued. So there is a onus on you to show the copy of the completion certificate.
My lord, what has been issued to us is an acceptance testing certificate, my lord.
That is in terms of the, see, that is the problem when you bypass the remedy available under the contract and invoke the writ jurisdiction. Under the contract, there is an arbitration clause. Assuming you have completed the work, there is a recheck, and they find that certain portions of the work are not to their satisfaction. They can ask you to redo the work. Writ petition is not the appropriate.
And my lord, in the agreement, my lord, there is a clause of arbitration.
That is what we are saying, sir. The mistake you did was you didn't appear when the matter was taken up on 9th of April. Writ petition was filed in 2016. You didn't file an affidavit in opposition. Now you raise all these contentions.
My lord, if my lords are, my lord, inclined to hear out this petition, my lord, may I make a simple prayer, my lord? I am led by Mr. Sinha in this matter, senior advocate Mr. Sinha. My lord, may it be kept, my lord, any day this week, my lord, he will be appearing virtually.
But then if you file a contempt petition, what will happen?
Lord, they were enjoying a stay application, my lord, and my lord can take it from me, lord. We will not file a contempt application in the meantime.
A/T certificate was issued in respect of one contract. Whether A and T certificate is a completion certificate. That is number one. The second hurdle is if the agreement between the parties provided for a procedure of resolving disputes, why should a writ petition be entered? In this appeal filed by the Bharat Sanchar Nigam Limited within bracket BSNL, two orders passed in the writ petition in WPA 2295 of 2016 and and 2298 of 2016, dated 9th April 2024 and 23rd April 2024 are challenged. It is not in dispute that when both the writ petitions were disposed of by order dated 9/4/2024, the appellant BSNL did not appear. Direction has been issued to the appellant to settle the outstanding payment to the writ petitioners. The appellant approached the learned writ court. No, the writ petitioners subsequently approached the learned writ court for necessary modification, and an order to the said effect was passed on 23/4/2024. A confusion had arisen as to whether the writ petition was classifiable under Group 9 category or Group 8. The writ petitioners had classified the matter under Group 8. Nevertheless, the matter relating to a contractual issue has to be rightly classified under Group 9. Therefore, these appeals are maintainable before this court, as this court has determination to hear appeals arising out of cases filed under Group 9. Two primary issues have to be answered by the respondent writ petitioner. Number one, whether the appellant BSNL had issued completion certificate to them in respect of both the contracts. And the subsidiary issue would be whether A/T certificate is akin to a completion certificate. Number two, the writ petitioner had entered into an agreement with the appellant BSNL in which a dispute redressal mechanism has been provided for, which includes an arbitration clause. Therefore, the respondent writ petitioner should satisfy this court as to how a writ petition was maintainable. The learned advocate appearing for the respondent writ petitioner submitted that he is being led by Mr. So-and-so learned senior advocate and seeks for a adjournment. Since both the above issue would touch upon the maintainability of the writ petition, and as to whether factually it was right on the part of the learned writ court to record that a completion certificate has been issued, the order impugned in these appeals shall remain stayed till the next hearing date. Let the matter be listed on 10th February.
One prayer. We have taken out affidavits in objection to two supplementary affidavits which they had filed. They may be taken on record, and I am serving copies of them also.
In place of 10th February, 11th February or 9th February,
9th February to Rovivar.
Oh, sorry, 11th February or 12th February, 12th February,
It is 12th February.
Grateful. I am intending to file the supplementary affidavit regarding the damage of the BSNL.
Supplementary affidavit filed by the appellant.
And our objection may also
affidavit
in opposition
filed by the respondent writ petitioner is also taken out of. This is item 16 and 17. Two matters.
17.
Interim order, kindly make
till the next hearing.
Grateful.
My lord,
In this matter, my lord, I am only 1 day accommodation, my lord.
Oui.
My lord, there is an learned senior advocate, my lord, who is leading me, my lord. He is today he is sick, my lord. That is the reason.
Wednesday, at the request of the learned advocate, in the same position.
Number 19.
Is finding the prejudice. How we can just clarify. May 10, 2027. Oh, defective out of. None appears for the appellant dismissed from all cause. I think if they are no longer interested, he is out of time.
Item number 20.
20 minutes, Maya. I get to appear on behalf. I am for the respondent number 9 and 10. But what happened, my lord, in this matter, my lord, I have purchased a plot of land. My name has been recorded in the record, present record of right.
Very good.
Now, my lord, while I want to raise the boundary wall, some of the villagers, they are raising objection. Now, I file a writ petition before this honorable court, and the my lord, honorable single bench, my lord, pleased to dismiss my writ petition on the ground that this is a civil dispute. Now, my lord, what I am trying to satisfy, my lord, that merely
No, you obtain an injunction, and from the civil court you seek for an order of
I
police
have a
protection.
civil remedy, my lord. There is no doubt on it, my lord. But what I am trying to convince, my lord, only one point, my lord, that though the subject matter is a land, my lord, until and unless someone put cloud on my title, or my lord, they are put cloud on my possession, or the court find that there is an extensive evidence is required to determine the
But then,
dispute.
sir, the police cannot, or the Panchayat Samiti cannot give you protection to erect the boundary wall. You, if suppose X, Y is Z or a private respondent objecting, you restrain him.
My lord, the difficulty is, my lord, I don't know, my lord, how many.
Jogeshwar Mahato,
My lord,
son of Balram Mahato.
That is a person who
And
is-
others.
and others, my lord, who is the leading person I have made party in this writ petition. But, my lord, today I
File a suit, I implead the defendant's representative capacity, take leave of the court, obtain an order of injunction,
But only
tell
thing-
the police.
We
they
will definitely do that.
They will willingly come and do that.
But kindly bear me only one bit, my lord. What I am trying to say, my lord, I have a remedy, my lord, under in terms of section 13 of the Police Act to make a representation before the superintendent of police, and at my cost, if the police found the police can provide me, my lord, the adequate police.
Very dangerous, sir, for the inspector of police to examine your title deed, measure, go to BLLRO.
Well, that is also not the scope of the writ petition, my lord.
I know, my lord, I know.
He's expanding the scope, my lord.
Mr. Sengupta, let me.
Sir, senior advocate, sir, he
Oh,
knows.
yes, I'm so sorry. Yeah.
My lord, what I am trying to say, my lord, only difficulty is, my lord, that this observation of civil dispute. Tomorrow, if, my lord, I come before this honorable court, making an application under section 13 of the Police Act to the Superintendent of Police, my writ petition would not be maintainable only on the ground that the previously High Court held that this is a civil dispute. That is the thing, my lord, which, my lord, my ground of challenge. And, my lord, only one thing, before, my lord, passing any order, Lordship kindly appreciate that whether the private respondent have any title, adverse title or adverse measure, whatever right, which needs, my lord, an extensive evidence. If they can satisfy, my lord, on any of the prima facie count, my lord, send me, my lord, I have to approach the civil court. There is nothing on their part. Though the writ petition, my lord, has not disclosed the reason, that is the why, my lord, I am not uttering the reason. But there is no ground on the part of the private respondent that they have a better title than me, or, my lord, the record of
All right, please hear the order. The unsuccessful writ petitioner is the appellant before us. In the writ petition, the prayer sought for was to direct the respondent authorities to take immediate steps under the provisions of law and take action against the private respondents, and to consider the claim of the writ petitioner as per their application dated 23/7/2024. The said application was given to the inspector in charge, Jalda Police Station, Purulia District, as well as the Panchayat Samiti. On going through the application, we find that there is an allegation that certain group of people, some of whom have been named, are objecting to the writ petitioner erecting a boundary wall. The learned single bench made a prima facie observation that the matter is of civil nature. However, there is no conclusive finding on that, on such an issue. Be that as it may, if the named persons or the other villagers are objecting to the appellant writ petitioner from putting up the boundary wall, it is essentially a matter of civil in nature. Therefore, if there are appropriate orders from the appropriate court, then the court, armed with such order, the appellant would be justified in approaching the authorities for further directions. Therefore, we are not inclined to interfere with the impugned order. However, it will be open to the appellant to work out the other remedies in accordance with it.
Yes. Further appears from the complaint lodged by the appellant before the inspector in charge that the dispute arose at the time of measurement of the land in question. Since the issue of measurement of the land resulted in the dispute, the writ court could not have entertained the prayer for pollution for construction of a boundary wall.
My lord.
Next.
Yeah, Item number 21.
Lordship, I am appearing for the respondent number 6.
It's the same issue.
Same issue, Lordship. Partial payment certificate amount has been paid.
Where is the earlier order which we have passed?
Lordship. Lordship, MET 2162 of 2024.
Copy not there.
Copy.
You just give the number. MET
MET 2162 of 2024.
2162 of
2024.
Date?
Date 17th of December 24.
Only the cost rate will change. Other things will not change.
payment, the contempt application has been made out of the list by Honorable Justice Mantha because the compound interest part is yet to be
That is
calculated.
there. In the earlier order also, we have protected that.
Yes, yes, yes.
Same order.
Yes.
You get that order as 2162 of 2024 dated 17. Dismissed.
On issues before.
This will be item 21 and 22. Patat, take a print of.
Lordship, in Lordship's earlier order, it has been recorded that the amount has been settled. It is not yet settled.
Partially settled.
Partially. Only the certificate amount has been.
Let's say partially settled.
Paragraph number 3.
Paragraph number 3, Lordship.
Have been settled. Only the interest is.
Compound interest part is pending. Certificate amount paid. And the contempt is also pending.
Sir, this change. Only this sentence you added. Next. Shanawaz.
Twenty-two.
Like 23 minutes.
In 22, payment has not been made. This money is secured with Learned Registrar General and the CPAN is disposed of. But we are not able to get the money from the office of Learned Registrar General.
Why? You take out an application in the contempt.
Because of this appeal, Lordship, we could not.
Then you do it. Give that order copy, sir. Sir, give that order.
Hey, so subduction.
The deduction, Lordship.
Nah, but
You give the case file. 23, 22.
আমি এটা নিয়ে মামলা করবো আজকে
পারবেন
এই যে একটা আদার সাইডের মাল এটা নিয়ে আমি জারি হোক আমি এটা নিয়ে মামলা করবো সবাই দেখাচ্ছে আমি দেখাতে পারি না
আপনার দেখার জন্য আরো অনেক কিছু আছে
সবাই দেখাচ্ছে খুলে খুলছেই না খুলতেই পারছি না
There is a direction to the Registrar General to transmit of funds as expeditiously as possible.
Not done, Lordship, till date because this appeal is pending.
All right. We have, this intra-court appeal is directed against the order passed in CPAN. A common order passed in a batch of cases, and this appeal is against an order in CPAN number 1335 of 2024. Identical appeals came up before this court on earlier occasion, and all of them have been dismissed. We find no ground to take a different stand in this appeal. Therefore, the appeal stands dismissed. The order and direction issued by the learned single bench dated 13/12/2024 shall be complied with, and the learned Registrar General of this court shall comply with the request of the certificate officer for transmission of the funds as expeditiously as possible, preferably within a period of 20 days from the date of receipt of the server copy of this order. With the above observation, this appeal dismissed. 23.
This is that matter when she was adjourned last occasion at their instance, Mlad. Mlad.
Mentioned this morning.
Yes.
Not only this
on
morning.
the very next day, Mlad, I mentioned.
Previous day also, they mentioned this
The very
matter
next
for-
time I mentioned, I'm
He broke upon your house.
there is an order of injunction. Only thing is, I'm late by Mr. Bhattacharya, Mlad.
Let us see what it
Yes. Mlad, there is an order of injunction. And Mlad, I'm making this submission. Kindly permits my senior man. I'll
what?
place the Mlad.
So senior is up.
He is on traveling, Mlad. That's the difficulty, Mlad. I talked to him. He was even available in the first half. Second half is traveling. There is an order of injunction, Mlad, restraining the defendant from disturbing my possession by the civil court. Now, Mlad, today I have prepared a supplementary affidavit.
But there is no provision. There is no provision in the eye of law for filing a supplementary affidavit in the appellate court.
To bring on record only.
It is under order 41/27.
That the order of civil court, order of injunction.
Now the learned judges directed the city civil court to endeavor to dispose of any application by the petitioner.
That has been executed. That part of the order has been executed, order passed thereafter.
What order was passed?
Order passed segregating the property. But there is a huge factual dispute in this matter that Reed Court cannot decide.
Three properties, 16 by 1A.
I cannot. Let him complete, then I'll.
I'm complete. I बोलेंगे किसी बोल मन दिए बोल
না না মাঝখানে বলবি
इधर औरत का दे मगे
People are very powerful people, is it?
It appears so.
Many senior advocates are up.
But I am for the poor tenant.
Poor tenant?
Tenant.
Poor, I don't know.
They have me. They might.
What was the prayer in the writ petition? You please come to page 33. Immediately restore possession. How can the police do that? You get an order of civil court with police aid. They will execute that order.
This is the order. After the order was passed, the civil court passed this order.
And you have filed revision.
Maintaining the injunction, but segregating the property.
I don't know what he has handed over, Blood.
Order. At your instance.
No?
Application for temporary injunction is allowed on contest.
Yes, but segregating the property.
Restrained from dispossessing the plaintiff from the suit.
That is what I was trying to file a supplementary affidavit explaining that my interim order that was allowed in my favor has been now confirmed.
That is correct. But you see the last paragraph, not last paragraph, in second page, just before the order portion.
Yes.
In the instant case, the plaintiff does not assert any right of tenancy in respect of 16(1)A, 16(1)B. So, if injunction is granted in respect of suit purposes, the property of the defendants 2 to 5, 16(1)A and 16(1)B will not be affected. So, you enjoy an injunction other than 16(1)A and 16(1)B.
We are not traveling.
So, if there is an obstruction in properties other than 16(1)A and 1B, you file an application for contempt before the civil court.
39(2)A here.
That remedy is there always my 39(2)A I can file. That is not here. Kindly see my prayer in the writ petition. And then I'll tell you, Rashim, what has happened. Why I am before the writ court instead of the civil court. Prayer C. This is important because I was evicted at the instance of the police and I have the videograph, entire video footage.
Now, therefore, you got an order of injunction.
No, after the order of injunction,
you enter into the property.
I was in the premises.
Yeah. Now you go inside.
Now,
no. If somebody.
Yes, now I can go inside. Can you clarify that? I can go inside.
Civil court order to be clarified with the High Court in a writ.
Why should we?
I understand. The difficulty is they want to dispose. In fact, they have dispossessed. After seeking adjournment from this court on the last day and on the very.
We will observe that as per order number 6 dated 23/12/2024 of the bench number 9 City Civil Court, there is an order of injunction restraining the defendants from dispossessing the plaintiff from the suit property till the disposal of the suit, and it has been clarified as follows.
No, we have not preferred any appeal against that order. We accepted the injunction.
Then this intra-court
This is
appeal
first part.
is directed against the order.
This first part, so that I can enter into the premises. The second part is that my specific allegation, this one is only 1 second when I'll take. That I have made a complaint at about 2 a.m. in the night. The order was passed. On the very next day, I communicated the order of civil judge. Now, on that day itself, during night, police came along with those goons. I have video footage. That's why prayer C I have made.
You make a complaint?
I have made the complaint
which authority they will look into the complaint?
That's why
you give it to the superintendent of police,
that I have
commissioner of police.
This has to be decided by the writ court,
No.
single judge. Can I remand that part only?
No.
This intra-court appeal is
may I have
directed
my
against order dated 17/12/2024 and WPA 29400/2024 by the said order. The writ petitions were disposed of and certain observations and clarifications were made. The operative portion of the order it reads as follows. Page number 3, sir. So, sentence start para starting so far till the end. Page 3, full stop. The impugned order was passed on 17th December 2024. It is not in dispute that the appellant writ petitioner had filed a suit in TS number 1998 of 2024 before Judge bench number 9 City Civil Court Calcutta, in which there was an order of interim injunction initially granted, and the application came up for extension of interim order, and the civil court has passed an order on 23/12/2024, which is to the following effect. From here.
This paragraph.
Mr. Mohammed Shamim, learned advocate appearing for the appellant, vehemently contend that the appellant writ petitioner was forcibly effected with the help of the police in the dead of the night, despite an order of interim injunction being in force. Since the civil court has passed a subsequent order on 23/12/2024, in which it has been specifically mentioned that the plaintiff, who's the appellant in this appeal, does not assert any right of tenancy in respect of either 16/1A or 16/1B Comidan Bagan Lane. And if injunction is granted in respect of suit premises, the property of the defendants numbers 2 to 5, that is 16/1A and 16/1B, will not be in any way affected. With this reasoning, the learned civil court came to the conclusion that the balance of convenience is in favor of the plaintiff, the appellant herein. The appellant is now armed with an order of injunction, and the said order of injunction appears to have attained finality, as the defendants 2 to 5 have not challenged the said order. Therefore, it is well open to the appellant to work out his rights based on the order passed by the civil court. Furthermore, we need to point out that when the matter is seized off by the civil court, it would not augur well for the writ court to interdict the process or give a finding on facts which will directly have an impact on the civil proceedings. There is an allegation that the private respondents forcibly entered the property at about 2 a.m. and with the assistance of the police evicted the appellant. In this regard, a complaint has been lodged by the appellant before the Commissioner of Police, Kolkata Police, dated by email, dated 6th December 2024. If the said complaint has not been inquired into, it will be well open to the Commissioner of Police to direct an inquiry to be done and necessary action be taken in accordance with the law after notice to all concerned.
But I have also made my subsequent.
Before that, Mr. Avitesh Banerjee, learned senior advocate appearing for the state, submitted that the allegation made by the appellant that police also aided the private respondents to evict the appellant is denied.
But so far, my lord, order of injunction is concerned that I can enter into my premises. That is.
All of us will go today evening.
But if anything happens, my police is render assistance.
You are powerful. Your client is very safe hands. He has come to you. He is in very safe.
But if anything happens, the police will render assistance.
Only law and order.
The only thing is that if anything happens,
nothing will happen.
But if any
number 9 is there, it is hardly stone's throw. You can get order.
If anything has police assistance, I can always pray for.
There's some background to it, I think. Yeah? Anyway.
I seek for police assistance at least. But otherwise, I have to face.
Please advise your client. Next. Thank you.
Item number 24. 24, I am for the appeal and malad. I am paying for only not this week because copy is not hard.
All right. List the appeal after service is complete. Next.
Item number 25.
In item number 25, Lordship, I beg to appeal on behalf of the appellant, Lordship. I led by Mr. Surrogacy Chatterjee and have served upon the state respondent, Lordship. He is the only answering respondent.
Who appears for the state?
Lordship, will have served upon the GP office, Lordship. So far, the name of the
Mr. Mukherjee is there. He will appear.
That is the affidavit of service, Lordship.
Who appeared in the writ petition?
Lordship, in the writ application.
What is this? Police help.
Yes, Lordship.
Petitioner
I have annexed the order, Lordship.
Harassed in connection with so and so PS case number so and so.
Yes, your Lordship.
Advocate for the state has produced case diary, submitted communication which was circulated, retrieved and been sent to the expert for cross. As commenced, this court grants an opportunity to police to collect the materials for the time being. However, having regard to the nature of acquisition, physical appearance may not be required of the complainant for the purpose of interdiction. Petitioner will communicate an email addressed to the IO. So also serve notice in mail, 48 hours interrogation, specify time and period. Could make herself available in virtual mode. Wonderful order, sir.
But Lordship, our contention is that, Lordship, that this FIR cannot sustain, cannot get effect, Lordship.
The writ petition is still pending.
Lordship, now the situation is that, Lordship, the kind
yes, Mr. Chatterjee, the writ petition is still pending. And through VC, your client can appear, and they will.
So far, the appearance she has already appeared.
Right.
The only portion is by which we are aggrieved of is that what you hear the impugned order kindly come to the
but for which affidavit in opposition has been called
the
for.
Mobile has been asked from this client.
Pardon?
Her mobile police authority is asking for the mobile. The mobile.
You file an application before single bench without a court's permission.
But you kindly direct that. I liberty. Otherwise,
we have heard the so and so, and Mr. Mukherjee, learned advocate appearing for the respondent state. Since we have directed Mr. Mukherjee to take notice on behalf of the respondent state, his appearance may be regularized. The order and direction issued by the learned single bench has worked itself out, and as the appellant petitioner has already been served notice, and she has also appeared online. Mr. Chatterjee, learned advocate.
So what we are aggrieved for, also kindly consider the internal page 2 of this order. As the investigation has commenced, this court grants an opportunity to the police authorities to collect the material for the time being. I'm aggrieved by that portions.
The learned advocate, Mr. Chatterjee, learned advocate for the appellant submitted that taking note of the observations made by the learned single bench, the police authorities are insisting upon the appellant to surrender her mobile phone. The learned single bench has directed affidavits to be filed and has also directed the matter to be writ petition to be listed under the heading contested application in the monthly list of January 2025. Therefore, it will be open to the appellant to file appropriate application seeking for appropriate orders in the pending writ petition.
Because of this police authority is acting. That is.
Why are you shy of giving your mobile?
Because the only thing is it would be the complete infringement of privacy. I did not make any comment which has revealed any cognizable offense.
All right. Next.
Lordship, timing can I be protected? Otherwise, I'll be
sufficient protection. Is
protection.
Next. 26 to 28. What is this specially fixed matter?
Mr. Mitra was making submissions. He was on his reply that, my lord, the license, liquor
This
license,
matter
my
was
lord.
heard, my lord, was on the, my lord was pleased to observe that I'm making in CAV.
No,
They
our
said
reply was
they said,
pending.
they
My
said
lord, our
reply had to be given.
Our
That's
reply
why.
was pending, my lord.
Now we require a recap. It's been long.
My lord, I understand it has been
With
long.
this festive season, let the festival all go. We have got Saraswati Puja, etc., coming long holidays. So let it go to the monthly.
My lord,
list
we
of-
have prepared a note, so that would be easy for Mr. Mitro to
disturb
take
Mr.
my
Mitro
lord through the thing.
Don't disturb him. There's no urgency.
No, my lord, he will be here. My lord, kindly makes it not today. He will be here, my lord. We'll come back.
Next Wednesday,
My lord, my lord,
Urgent matters, madam.
kindly.
You know, you are also appearing.
My lord, kindly.
Every day there are 10, 15 lawyers mentioning.
My lord, I understand. My lord, kindly keeps it. My lord, will come back. My lord, it won't take much time. My lord, the note would help, my lord.
Stock is lying with you. And Mr. Mitro said, nothing will happen to the stock.
Yes, but the older the better.
My lord, that does not apply to all the liquors, my lord. That is the difficulty. That might apply to some.
26, 27, 28.
My lord, 26 and 28, my lord, we are appearing. My lord, 27, my lord, not.
Let it come together.
My lord, kindly makes it not today. My lord will not take much of my lord's time.
Indeed, we have heard these matters for a substantial length of time, but that was about 3 months back. About 3 months back. Therefore, to take a decision, we have requested the learned senior advocate for the appellant and the learned advocate general appearing for the state to give us a brief recap. For such purpose, let the matter be listed in the monthly list of February under the same caption. Thank you. Next.
My lord, kindly let it retain the position, my lord. Under
Same caption.
My lord, that is, I'm grateful.
Item number 29.
Lordship will appear for the respondent, your lordship. Praying for 10 days time extension for filing by AO. Lordship. Filing the opposition.
Opposition.
Lordship, I beg to appear for the appellant in this matter, Lordship.
They want time to file
10 days time.
10 days time.
Lordship, this may be given as the last chance then, because on the last occasion itself, they had sought time.
Learned advocate appearing for the respondent prays for 10 days time, extension of 10 days for filing affidavit in opposition. The prayer is opposed by the learned advocate for the appellant and would submit that this may be the last opportunity that may be granted to the respondent. The respondents are permitted to file their affidavit in opposition not later than 24th of January 2025.
Wait,
after serving advance copy on the learned advocate for the appellant. If the respondent fails to file the same, the affidavit in opposition will be accepted subject to the condition that the respondent pays a sum of rupees 1 lakh to the appellant.
Obliged, Lordship.
Within 3 days, the affidavit will come.
Your lordship, the authorized representative was actually.
He is financier, and you default, then what they will do? He is virtually
absolutely.
in fact, they are a partner to your business. Without their advances, you could not have run the business. And now after everything you have enjoyed, you have diverted all the funds here, there, bought Mercedes Benz.
The authorized representative was busy with the audit, Your Lordship. We have finalized just 10 days for filing.
Lordship, this was prayed on last year's November. That is why, Lordship, I'm
Yes,
opposing
yes.
it.
Very good.
Wait, Your Lordship.
Obliged, Lordship.
And some. Yes.
The Supreme Court pending.
Next.
Item number 30. 30, my lord, I beg to appear with the appellant, my lord. My lord, I am led by learned Advocate General and my lord, Mr. Gal. My lord, this is the surrogacy matter. Age bar is involved, my lord. Issue of the age bar is involved, which is pending before the Honorable Supreme Court, my lord.
11 February is the next date fix.
Some order.
Some order has been passed by the Honorable Supreme Court in this matter.
11 February is, I've been, 11 February is the next date fix.
Some order was passed, thereafter the next date has been fixed.
My lord, there's number of orders. One of the orders, my lord, the Supreme Court has observed. I have handed over a bunch of orders in the last occasion. Lordship kindly takes up page 40.
In fact, Victor, we suggested to you, why don't you intervene in that matter?
Well,
suppose we pass something which is inconsistent, and it's a very proactive.
Well, only one thing, my lord, kindly considers this observation of the Supreme Court, my lord. In the bunch, I have handed over a bunch of orders on the last occasion.
Which is the order you want us to see?
My lord, page 42 is the order dated 5th of February 2024 at page 46. Yeah, my lord, in the middle of the page, my lord.
It is said that High Court can
My
take
lord.
up the matter.
Liberty was granted to the applicants who preferred applications before the Supreme Court to approach the.
All right, now it's listed on 11th February.
11th February.
So we'll keep it post 11th February. Let us see what happens.
Well, as per the matter is concerned, my lord, I've checked all the orders, my lord. There is a dispute issue regarding the age, but the age issue, my lord, not relating to the mother, relating to the surrogate. Whether she can donate after the age of 35, there's a bracket 35 to 45. If she crosses, whether she can carry out the process of surrogacy. But my case relates to the age of the parents.
Adoptive parents.
Yes, my lord. Regarding the age of the parents, but I have not seen a single observation in the Supreme Court orders.
We list it on 19th February under the same caption. Please record the appearances of the learned advocates. Next.
There are two appeals, one by the central government, another by the state
Both
government.
in the matter or the writ petitioner respondent number one.
The past matter is our appeal. This is relating to grant of freedom fighters pension to the legal heirs of the original applicant. Now, the original applicant made an application. There was several proceedings. Time and again, it was rejected by the state government for non-availability of records. A writ petition was filed.
His name did not appear.
And actually, ultimately, the matter was forwarded to the central government by the state government, the recommendation. But the original applicant died. Now, during the pendency of consideration of his application for grant of freedom fighters pension. Now, the wife, who is the original legal heir to get the pension, She also died during the pendency of the writ petition. Thereafter, after a long lapse of time,
It was dismissed.
all the legal heirs of the original applicant were substituted. Now, the basic point I took on the last occasion was that in view of the scheme, if the application is kept pending and during the pendency of the application, the original applicant dies, there is no question of granting pension to the other legal heirs. That apart, the scheme also provides whenever an application has to be made, a declaration has to be given who will be the nominee after the death of the original pension holder. So, my lord, thirdly, my lord, there was no availability of records. It is admitted fact. There was nothing mentioned about the original freedom fighter in the official records of the government. That is admitted.
They have gone through the record.
And then they relied on a secondary evidence, a certificate of Mr. R.N. Giri, who was a freedom fighter. Now, this particular matter of Mr. R.N. Giri's certificates came up before the Supreme Court. There were some allegations of fake certificates in the name of R.N. Giri, and there was an inquiry ordered by the Supreme Court. Now, we are not aware what is the latest outcome of that inquiry, but we can satisfy your lordships from the records that there is an inquiry. Now, first, may not kindly come to page 173 of the stay application. Of my stay application, the first matter, item number 31, first matter. Page 173 of the stay application.
1.5.
My lord, has your lordship got it?
Yes.
The scheme 1.5. This is very important. Sanction of pension after the death of freedom fighter. No pension shall be sanctioned in the name of the freedom fighter after his/her death, even his/her matter was under examination. This is also entails that no lifetime arrears or dependent pension shall be sanctioned to his/her spouse, daughter after the death of the freedom fighter. Now, this particular provision has not been challenged. And this is exactly the case here. The original freedom fighter died, the wife died, and during the pendency of the writ petition, all the legal heirs were substituted, even the married daughters. Therefore, on this score only, the learned single judge did not consider this provision. Nor did he consider that the certificate issued by Mr. R.N. Giri is in under question before the Supreme Court. And that may not kindly come to R.N. Giri's that has been, this particular point was taken in the affidavit in opposition at page 116 and 119 of the stay.
The ground of rejection was because the state did not recommend the proposal.
Yes.
I think that
State
was
did
the
not.
only ground.
Throughout the state.
Yes.
The records are not available. But
Records are not available.
adverse presumption has taken because 80 years old document, 1942-43, record could not be produced. It is not available. And 13 years. His age was 13 years at the time of underground. Is it believable?
We have got a statue of a person whom we honor, who was a young boy.
Master Surjosan.
There were people at those days, even at the age of 10, they had the.
And Khudiram Bose also?
No, he was 18 years. 18
When
years.
he joined, he was 13 years.
13 years, undergone.
Sir, before that, please show us the order of rejection which was challenged in the writ petition.
Yes.
Yes.
That your lordship will kindly find the writ petition. We have annexed in the stay application.
Lordship, page 79, annex
79.
The state's rejection. This is the
With reference to, may I read, my lord? With reference to your prayer dated 23rd September 91 on the subject noted above, I am directed to inform you that your case was considered on the basis of relevant data submitted by you. but it is a matter of great regret that your case could not be recommended to the Government of India for the following reasons. Your claim of suffering has not been established from official records. This was already intimated to you under this department's letter number such and such. This was challenged.
Lordship, then thereafter
Then
93.
where is the order passed
93.
by the central government?
93, Lordship.
93.
93. Page 93. Okay.
This has a reference to the order dated 14th February 2001 passed by the Honorable Mr. Justice Amitabh Lala in such and such. The matter is forwarded to the respondent number 5, Deputy Secretary, Government of West Bengal, Home Department to reapprise the matter under the guidelines as given by this court and forward the matter for the purpose of giving pension to the Government of India within a period of 2 weeks from the date of communication of this order, so that the actual pension can come in the hands of the freedom fighter within a period of 4 weeks thereafter. The relief of pensionary benefit will be given from the date of making such application. Thus, the writ petition stands disposed of. There will be no order as to cost. This is the order passed by His Lordship. In compliance with the above order, the Government of West Bengal vide letter number such and such intimated to the Undersecretary to the Government of India and endorsing a copy of the as under. In compliance with the order dated 14th February 2001, passed by the Honorable High Court, Calcutta, I am directed to state that the court directed the state government to forward the case to the Government of India for the purpose of giving pension to the petitioner. The case is hereby forwarded to the Ministry for grant of Samman pension to Sri Ramlal Maiti as per court's order.
Thereafter.
Then, thereafter, Government of West Bengal, video number such and such, intimated to the Undersecretary to the Government of India as under. In continuation of the department's letter number such and such on the above noted subject, and to state that report from
I think you, ASG must skip all that. Come to the last paragraph.
Yes. In this connection. In this connection.
You may be informed that under the provisions of
In
this
this connection, you may be informed that under the provisions of the Swatantra Sainik Pension Scheme, the claims are to be established on the basis of primary evidence, official records. In case such records are not available, personal knowledge certificate from the eligible certificate is acceptable in respect of the underground claims. In instant case, your claims is based on the basis of the secondary evidence, personal knowledge certificate from the R.N. Giri, a freedom fighter. The West Bengal government has now informed that primary evidence, namely official records, are available as stated above, as per the report of DIG IB, West Bengal, and SP DIB Midnapur. But your name does not figure as a political sufferer during
So there are two aspects. Under the scheme, if primary evidence is not available, secondary evidence is there. Co-prisoner certificate, etc. It is accepted by the central government that the claim made by the original claimant was based on the personal knowledge certificate given by R.N. Giri. The second ground of rejection is state government has said there is no official record. So if you eschew that state government's report, what have you to say about the personal knowledge certificate of R.N. Giri?
Exactly, my lord. This matter went up to Supreme Court. My lord, I have stated in so many paragraphs and our affidavit in opposition that the certificates indiscriminately issued by R.N. Giri were in question. There are certain fake certificates of R.N. Giri. Kindly come first, my lord, to my affidavit in opposition at page 116.
2,229 certificate, fake certificate. According to CBI is holding inquiry. In my application, page 213, order of the Supreme Court.
160.
Now kindly come to page 119 of the affidavit in opposition. May I read, my lord, this clause 5, that the claim of the petitioner is on the basis of the secondary evidence, namely personal knowledge certificate issued by Sri R.N. Giri, whereas the government of West Bengal had informed that primary evidence, official records are available. But the name of Sri Ramlal Maiti does not figure as a political sufferer during pre-independence days in the official records. Moreover, the certificates issued by Sri R.N. Giri have no weight and have been severely criticized in a series of judgments passed by this Honorable High Court in FMA number such and such, WP number such and such. Sri R.N. Giri had misusing his status as a freedom fighter and issuing secrecy indiscriminately. Now kindly come what is the order passed by the Supreme Court?
Page 220.
Page
220.
220.
Starts 218, 220.
Yeah, starts 280.
Yes.
আরো পরে
আচ্ছা,
আরো পরে যা 20 যা
20 থেকে শুরু, অর্ডারটা শুরু 20 থেকে।
Yes, 220 is relevant, page 220. Learned counsel appearing for the petitioner submits that as per his instruction, the process as contemplated by the orders dated 27th April 2022 and such has indeed been taken forward, and final orders have been passed in relation to 198 cases disapproving the personal knowledge certificates stated to have been issued by the CRN Giri, and consequently the freedom fighters' pension, wherever allowed in relation to these cases, have also been cancelled. Learned counsel further submits that as per his instructions, as regards the certificates issued by Sushil Kumar Dhara, 47 notices have been issued and the proceedings are underway. The submissions are taken on note of. Learned counsel for the parties may file additional affidavits as also short notes on their proposed submissions before the matter is taken next.
Now, what happened to that matter?
That inquiry report.
No. List the matter for directions on 10th of April 2023.
No,
What
thereafter,
happened?
We have to get
thereafter we have to give instruction. What is the latest
This is the
position?
point.
About the
subsequent
an inquiry ordered by the Supreme Court itself about the RN Giri certificates.
No, RN Giri certificates, he has indiscriminately issued certificates, and wherever cases were issued, freedom fighter pension were cancelled.
Cancelled.
So, if was any order of such cancellation challenged, and any judgment has come forth?
No, about that point also you have no instruction as of now. But your lordship is kindly consider only this aspect. Whether
we'll come back to you. Sir, your claim.
I understand. Not to reply, you let me learn. I will answer every point.
Please just give us a small answer. Keep aside the other things, legal errors, etc. Now, it is an admitted fact that there is no record to prove that the original applicant was a freedom fighter or a person who has gone underground. The state authorities have made it clear. The claim made by the applicant was solely based upon a personal knowledge.
Certificate of RN Giri.
Yes, that is a personal knowledge certificate, or it's also called as co-prisoner certificate. Now, this PKC, which was issued by RN Giri, is under cloud. So, eschewing that, you have to establish.
First of all, in a read application before this court, criticize about the certificate of Mr. Giri was raised. That order was challenged before the division bench of this court. The division bench of this court, setting aside the judgment of the trial court, in which the criticize was made, will not allow the appeal. Subsequently, that was challenged before the Supreme Court, and the Supreme Court dismissed that appeal. Subsequently, in a case where my lords approved or allowed the appeal regarding the area of payment to the heirs, that has been having been upheld by my lord, king in the division bench, an SLP was made. In the SLP, that has been also been dismissed.
That is correct.
That too, as regards the certificate of RN Giri, the Honorable Supreme Court not has stayed any order of the Honorable High Court.
Supreme Court Supreme Court cannot set aside RN Giri certificate. Supreme Court has recorded that this man has given 198 false certificates based on which sanction of pension has been cancelled.
Not cancelled.
No.
Not yet cancelled. Not a single cancel.
Sir, it is recorded.
Notice has been given. Well, so far my knowledge goes, not a single case has been cancelled. Rather, as per the order of the Supreme Court, pension is being paid, in which RN Giri certificate has been granted.
Sir.
In the case of Indu Bhushan Jana, wherein my learned friend Mr. Chandiri Alam was appearing. She knows.
Let us assume RN Giri has given 250 certificates. Before the Supreme Court, it was reported 198 certificates is fraudulent. There may be genuine certificate.
Yes.
But here, Honorable Supreme Court records that consequently the freedom fighters' pension, wherever allowed in relation to these cases, have also been cancelled. It may not be in West Bengal. It may be elsewhere also.
I may not so much, it is on the basis of the report
Page
submission. Page 220. On the submission of the learned ASG in the Supreme Court, this was the mention. They said that they have to issue notice.
No, we will.
But not a single case has been cancelled.
No, we will direct
Wherein also
Indian government,
favor of my clients, one notice
government to
was
file
given.
a supplementary affidavit bringing on record all action taken pursuant to the cases where the certificate issued, PKC certificate issued by R. N. Giri was held to be either not valid or fraudulent.
Apart from that, the scheme also provides that in the event after grant of pension, it appears
yes,
that it
can
has
be
been
cancelled.
fraudulently obtained.
With
The
all
government has
those
jurisdiction to cancel.
We will
on
go.
the basis of that, and
that-
not a single
No,
case has been cancelled.
No, let my learned friend answer that page
Sorry,
173.
In all the dates before
Mr.
the
Manna,
Supreme Court, I am appearing on behalf of the freedom fighters.
Very well.
So I know what are the orders. If your lordship so desires, I can hand over the entire bunch of the orders. About 38 orders. I got with me.
We will do that. Before that, we will ask the union, appropriate authority of this department, to file an affidavit clearly stating as to because
Which case has been cancelled?
how many cases where pension has been cancelled, and whether any of those cases where cancellation has taken place was challenged in any other high court.
Yes.
Some judgments.
That apart may not kindly consider this, which I had the privilege to draw your lordship's attention, that the basic foundation of continuation of the grant of pension to the legal heirs, all the legal heirs, is not supported by any scheme.
That is second
That
stage,
is
sir.
decided by my lord, which has been affirmed by the Supreme.
No. We'll come to that. We know the facts of that case. Justice Ajay Kumar Gupta was with me. That is different. First we'll go.
Very well, we shall file an affidavit.
This Giri certificate goes means everything goes.
Everything goes.
Yes. All right. We have heard the learned additional Solicitor General, as well as Mr. Mukherjee, learned senior standing counsel for the appellants, and Mr. Manna, learned advocate, appearing for the respondent petition. Before examining the various contentions which have been advanced in both the appeals, namely the appeal filed by the Union of India, as well as the appeal filed by the state government. Come on. We have taken note of the order passed by the Honorable Supreme Court dated 14/2/2023 in special leave petition within bracket civil diary numbers 15039 of 2019. Union of India and others versus Rampada Panja and others. In the said order, the Honorable Supreme Court has recorded as follows. Sir, page 220, sir. With pencil. Recorded as follows. Taking note of the submissions which were made. Please extract those. It is not in dispute that the original applicant who applied for freedom fighters pension in the instant case had applied with a personal knowledge certificate stated to have been issued by R. N. Giri. It is also an admitted fact that the state government has filed a report that no records are available where the applicant to show that he was a freedom fighter or a person who had undergone during the freedom struggle. In the above order passed by the Honorable Supreme Court, taking note of the submissions made, it has been recorded that in 198 cases, it has been stated that Final orders have been passed in 198 cases, disapproving the personal knowledge certificate stated to have been issued by R.N. Giri, and consequently the freedom fighters pension, wherever allowed in relation to these cases, have also been cancelled. The learned advocate appearing for the respondent petitioner submitted that to his knowledge there is not a single case where freedom fighters pension was cancelled on the ground that the certificate issued by R.N. Giri was not a valid certificate. However, the Honorable Supreme Court has also taken note of the instructions given to the counsel appearing that as regards certificates issued by Sushil Kumar Dara, DHARA, 47 notices have been issued and proceedings are underway. Before we consider the grounds raised in both the appeals, as well as the contentions that may be advanced by the learned advocate for the respondent, we direct the appropriate authority of the Government of Union of India / appropriate department to file an affidavit giving full particulars and statistics as regards the final orders which have been passed in respect of applicants who have submitted freedom fighter pension application supported by PKC certificate issued by R.N. Giri. In the event those orders have been challenged before the High Court, such details may also be furnished in the affidavit so as to enable this court to consider the contentions which have advanced. List the matter on 19th February.
One line matter, because state government was imposed penalty of rupees 70,000 for non-production by records. That order may be stayed.
In the light of the above order, the direction issued by the learned single bench directing payment of cost shall remain stayed.
Apart from that, the last order, my lords had been pleased to direct my learned friend to give an undertaking that he shall not proceed with the contempt application.
The undertaking which was given by the learned advocate for the respondent writ petitioner
matter is pending before my lord, how I
not
can
to proceed with the contempt petition filed before the learned single bench shall continue till the disposal of the affairs. Stop with this.
my lord, let that truth come out.
Yes.
Before rising, my lord, could I seek my lord's indulgence? But I'm sorry, my lord, I didn't attain the item number 22. My lord, on merit, your lordship has been pleased to dismiss because I am for the stay. Well, if your lordship kindly allow me, my lord, to place my name, my lord.
Yes, sir. Your name will be placed. There are almost 20 appeals we have disposed.
Keep obliged.
Thank you.
22. Obliged, your lordship.